My lord, may I permit for correction?
Lordship, the Lordship's permission, I'm mentioning two matters for inclusion in your Lordship's
What
list.
matter?
Lordship, appeal.
Call on this.
My appeal now. It arises out of a decree of partition, but this is first time.
Use the microphone, Mr. Mukherjee. Yeah.
It arises
Partition?
out of a decree of partition where I was a defendant.
Preliminary or final?
Preliminary. Is this appearing for the first time? May I just
Yes.
usual orders I'm paying?
The present appeal arises out of a preliminary decree of partition. Full The appellants shall serve copies of Can 1 of 2026 on the respondents.
Respond no, my lord. All of them are plaintiffs, my lord.
Partition suit. Server note.
Oh, very well, very well.
Respondents as well as the pro forma respondents, indicating that the application shall next be listed in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellants. The learned trial judge shall continue with the final degree proceedings, but shall not draw up any final degree without the leave of this court till disposal of the application.
I'm great.
I will also put in the pass the necessary.
Yes, my lord. I'll bring the LCR at my cost.
Yes. The trial court record shall be brought by special messenger at the cost of the appellants, to be deposited within a week from date. The trial court shall be entitled to retain skeletal records for the purpose of continuing with the final degree proceedings. Stop. Next para. The appellants shall deposit postal cost requisites and written up notice form for service of notice of the appeal on the respondents within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants.
I'm grateful, ma'am.
Partition we made it the usual. Respond.
It has come after a long gap, my lord. I should take instruct the client. It is
But time for the applicant. Time for the applicant.
Yes.
Well, it was order appointment rule 27 application has also been filed, my lord. Probably that has not been served to my understanding, my lord. I will serve him, my lord, and thereafter kindly take up, my lord, and next step, my lord. But one is the application and another is, my lord, order appointment rule 27.
Copies Mr. Mahato is appearing, serve on him.
Yes, my lord. I will serve them.
Since Mr. Mahato, learned advocate, has instruction to appear on behalf of the respondent, the learned advocate for the appellant shall serve copies of the applications on Mr. Mahato. Full stop. The matter shall next be listed for hearing on, give us a date, on August 19, 2026.
My lord.
Next Wednesday, yes.
Lord, the defendant is the appellant before your lordship, Lord, in a suit for, Lord, recovery of money on account of goods sold and delivered. Lord, purchase order was issued, and Lord, the claim is on account of that purchase order.
You are the plaintiff.
I am the defendant. I am for the defendant. Lord, in effect, the suit, Lord, has been, Lord, taken up ex parte. Lord, I've checked up the record.
First, you have to put in the dictator.
Yes, Lord, on that, Lord, I make some submission, Lord, that in this case, I might not even need, Lord, it's always a discretion of your lordship. But I might not even need, Lord, to put in, Lord, the amount indicated. The first, Lord, my point is that the cause title of the plaint, in the cause title of the plaint, the plaintiff says that, Lord, the address of the plaintiff, that is the source of jurisdiction, is the registered office. From the evidence, it is found that, Lord, there is no registered office at that address. Lord, far less, Lord, keeping that aside, the plaintiff could not even prove that the plaintiff is operating any office from that address. That's my first point. And the court observes that that particular address.
The plaintiff pleads that it's his, the plaintiff's office, registered office.
That is the jurisdiction. Because I stay in, admittedly, Delhi. The amount.
Lord, Amta address has been given in the plaint.
My lord.
Amta, Howrah.
Exactly. Lord, the court holds that that is the registered address. Whereas from the evidence, it is seen that it is not the registered address. The registered address is in Hyderabad.
But you
And
have to look into that. For that, you
Lord,
cannot
from
be
the-
this cannot be mitigated. You have to put in the decretal
Lord, from the records, from the Lord, judgment itself, I can show one. Lord, that's one. Lord, second is there is no evidence or no pleading that the plaintiff is an MSME, although he asks for the interest of MSME at the rate of MSME. The court proceeds on the basis as if it is MSME and Lord grants interest at Lord the rate of 3 times the bank interest. Lord, that is the second. The third one, Lord, that is 65B of the Indian Evidence Act, Lord, has not been complied. Despite that, the emails have been taken on record as evidence. Fourthly, Lord, these are all points which I can even argue whether my written statement is on record or not. Lord, fourth point, the person who has deposed on behalf of the Lord plaintiff, Lord, from the authorization submitted, Lord, it cannot be seen that he had authority or power to depose.
But the decree says it's allowed on contest.
Yes, Lord, I was contesting. I had filed my written statement, but unfortunately, Lord, I do not know why, Lord, it was, Lord, never
These
proved.
points are available to you if you appeared in the
Lord, these points have been taken. Lord, these points have been taken. These points have been argued, decided.
adjudicated either way, but you have to decide that in the appeal itself. How can
Lord,
you
if
at this
this
stage?
is, if this,
Decretal amount. Decretal amount you have to put.
Lord, if the perversity is on the face of the record, the Supreme Court says, Lord, I'm
Interest we are not directing to deposit obviously. Without the interest, only the principal amount you have to decrete.
Lord, may I just place, Lord, for your Lordship's kind consideration, the judgment which says
Yes.
that even without, Lord, if this is the situation, then without, Lord, any security, Lord, not always cash security, but other security, Lordships direct to, Lord, to. But in this kind of a case, Lord, without security also, my Lord will, Lord, consider it to Joseph. Lord, paragraph 86 to 90 and 138.
to
90 and Lord 138. It's a longish judgment, Lord. Download है ना? Good. Lord, may I place it for your Lordship, Lord?
You should see in the first 4 paragraphs and 138 will just see.
Lord, I'll take your Lordship straight away to 138. Lord,
Yes.
186 is basically, Lord, the finding, and thereafter the direction is at 138.
The conditions are given when it will not be 86.
86.
4 situations under which these are to be considered exceptional case.
When I need not put in the security.
Right. Let us see 130.
And 138, Lord, are all the parameters set? Your Lordship would find at page 1, paragraph 138.9. And Lord, because of para 139, I am sure, Lord, this has already reached your Lordship. 139, the Supreme Court was
Regularly some
everywhere.
things reach us, but we don't have the time to go through all of them.
No, Lord, this is, I mean, my respectful submission, Lord, this
Requires a
judgment
bit of appreciation of evidence, Mr. Karmak. It can be said to be egregiously perverse.
apparently, Lord, kindly takes, Lord, the memo of appeal.
Yes.
And Lord, the plaint. Plaint the copy. To yourself. Lord, first I'll take your Lordship straight away.
The territorial jurisdiction point was taken by you.
Yes, Lord, that has been decided, the first issue. Lord, the kindly comes to
Yes. Page 9.
Page 9. I'm grateful. Now, my lord, kindly. Master data work.
Yes, a reason has been given. Going back clause C of section 20, appears that business transaction between the parties is undertaken and plaintiff, one of the parties to the transaction, has its registered officer.
Registered office. So, my lord, this is, my lord, kindly sees the
Oh,
plain.
Sherpur is gone. But
Anta.
also, no, the registered office has its registered office
Exactly.
within Anta.
Exactly.
The plaintiff has it within Anta.
This is what is the finding in issue number 1. Kindly, my lord, comes to paragraph number, page number 13.
But that also, it also says a part of the cause of action arose here.
Lord, part of the cause of action arose here, holding that it is the
Actions.
registered office.
13, page 13.
Page 13, Lord, exhibit 11, third paragraph. Lord, this is the exhibit 11.
Hmm.
Lord, kindly excuse me, Lord.
We have to
This,
look into these
Lord,
documents.
this is
This
primary.
recently
Lord, this is
published.
ex specie.
No,
Lord, kindly
not
sees
ex
the
specie.
registered address. This is the court holds exhibit
Ex
11.
specie we could not find anything.
Lord,
Ex specie means on the face of the judgment.
Lord, court records this master data.
That to be decided.
Court finds that this is the registered address available in the master data. Lord, kindly sees what is the master data saying.
Court believed that a part of the transaction occurred in within jurisdiction.
But holding that that is a registered address.
No, not only that. Two grounds, both the grounds are given. It says it's conjunctive. It appears that business transaction between the parties has undertaken, and the plaintiff being one of the parties has its registered office. Not that because it has its registered office.
One of his parties has its registered office. Lord, that itself is bad. That itself is perverse.
They have shown one of the addresses at Amta.
None of that could not be shown. Lord, because
That is
exhibit
not that-
11,
How do we have to look into the evidence for that, Mr.
Lord, only exhibit 11. That's one. That's one. If your lordship is not satisfied with that for the time being, Lord, then 65B is compliance, which is my lord apparent. It's a mandate.
Emails relied on.
Lord,
Where are
oh,
the
acha,
emails?
acha. Lord, I'll just take your lordship. Lord, kindly comes to page 11.
Did you take
These
an
last
objection as
paragraph,
to
the first email was on such and such.
Did you take an objection as to 65B?
Lord,
Does it appear?
Lord, 65B is, Lord, even if I don't take objection, it's a mandate cast upon the court. Like section 3 of Limitation Act.
Can be satisfied even without that. Can be satisfied.
Lord, 65B compliance is a mandate the Supreme Court
That's a
is
legal
saying.
error, not a patent perversity.
But
Some
if
evidence
it's-
was produced, court relied on that, and court came to a finding and has passed a decree. We cannot at this stage of grant of stay decide that conclusively. MSME, no.
MSME, nothing. No pleading. Kindly sees the plain
Do you
time.
object to there being an MSME?
Yes, Lord.
Where is that?
Lord, MSME
Supreme-
finding. I'll take your lordship. Lord, kindly comes to the page number 14, the last paragraph onwards.
Yes.
Proceeds on the basis that it is MSME. In the entire judgment, there is
There is no
nothing.
objection to that. No issue on that.
But it is, he has to show that he is MSME. He has not
unless
pleaded.
Unless you object, court can proceed on the premises. It
But
goes by
there
non-traverse.
has to be a pleading to that effect. Kindly sees the plaint once. There is no, I just hand it up to your lordship. ওইটা না এই যশারকে দিলাম প্রিন্টেড কপিটা জেরক্স it should be a photocopy মিলার there is nothing in the entire plaint 7 except the prayer A, which says I want an interest at the rate of MSME 16%. To go down not situated.
What's your written statement, Mr. Kormak?
No, written statement, Lord, although it was never proved, but Lord,
Not
The
proved,
written
never
state-
proved means?
Lord, the appellant, Lord, never faced examination.
No, not at this stage.
He had to prove, Lord, it's his case. He never made out that
Written
case.
statement, where is your written
Yes,
statement?
I have the written statement. It was filed. But
You
Lord,
take this point that
but-
they are not entered as an MSME. Let us see.
Ache na?
Show that portion.
Yes, Lord, I'll just leave it. Cross ache na? Just a minute. Yeah, Lord, page 19, this is paragraph number 29 of my written statement. Kindly, Lord, excuse me, this is only. Just above paragraph 30, MSME has no application.
Therefore, MSME determines the interest rate.
Only.
Interest, we are not directing to put it. We are directing to put in the main amount. MSME, yes, you may have a good point. Others also, you may have a very good point. But these are matters to be appreciated in the appeal.
Wait, Lord, 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 these were my respectful submission. Only one thing, Lord,
We'll give you some time to deposit.
Lord, the
then
money
answer.
aspect, Lord, my client is a bit, Lord, he has, Lord, if your Lordship permits, Lord, I have obtained, Lord, the title deed of his property worth 2 crores.
Cannot look. If the money decree is ultimately upheld, then what happens? Your property will be attached.
Yes,
Otherwise, you'll
Lord,
go to jail.
this property is worth 2 crores.
Maybe.
Lord, that title deed, Lord, I can, Lord, this is the only thing that I have.
No, we cannot directly deposit a title deed in a good. We are not Shylocks.
That
We are
has also,
Shylocks, but
that
not
has
Shylock
also
of
been,
that order.
that has also been done.
We are not Shylock of that order.
That has also been done.
We are Shylocks of a lower order.
Lord, in
Shylocks for others.
an
You don't
order,
require
order
your money,
38
you want to
proceeding,
see the color even.
in an order 38 proceeding, the court finds, Lord, there is no prima facie case, but directs furnishing of security and, Lord, finally, ultimately, automatic decree. That's the order passed. And finally, Lord, I was saved by putting in my title deed in the other proceeding, not here.
We'll give you 4 weeks time to deposit. Till then, unconditional. If you don't deposit, it will be vacated. What
Lord,
can
I understand, Lord, but the difficulties, Lord,
The present appeal has been preferred against the money decree. Full learned counsel appearing for the appellant submits that even the foundational facts for granting a decree with a component of interest under the MSME Act was lacking. Full learned counsel submits that throughout the plaint, there was not a single averment by the plaintiff stroke respondent as to the respondent being an MSME unit. Full stop. However, the trial court, the learned trial judge directed interest to be paid in the at the rates stipulated under the said act. Full stop. Next para. Secondly, it is argued that the premise of the territorial jurisdiction of the trial court, as pleaded in the plaint and recorded by the learned trial judge, was that the registered office of the plaintiff stroke respondent is within the jurisdiction of the trial court, which, however, was not established by any evidence whatsoever. Full stop. Next para. Thirdly, the learned trial judge relied on certain purported printouts of emails without compliance of section 65 capital B of the Indian Evidence Act. Full stop. Next para. Learned counsel submits that due to such ex facie perversities in the judgment, the court may waive the deposit of the decretal amount as condition for grant of stay. Full stop. In support of his contention, learned counsel cites such and such reported at 2026 3 SCC 641. Full stop. Next para. From paragraph number 138.9 of the said report, we find that the Honorable Supreme Court held that a lodestar, LODESTA, lodestar for bringing a case within the purview of double-endoted exceptional case for the purpose of granting benefit of unconditional stay of execution of money decree by the appellate court would be, comma, if the money decree in question, colon, niche Roman 1, Roman I, is egregiously perverse. এটা একটু 138.9 থেকে আপনি সেট আউট করে দেবেন, শুধু ওই চারটে 1 থেকে 4 ফুল স্টপ। নেক্সট প্যারা, in the present case, comma, however, comma, the contentions of the appellant, comma, though well arguable, comma, do not and are not of the nature of a patent perversity ex facie evident from the impugned judgment itself. Full stop. Next para, insofar as the jurisdiction is concerned, comma, the learned trial judge did not only rely on the registered office of the plaintiff respondent being within its jurisdiction, but also observed that part of the transactions occurred within such jurisdiction, comma, as such deriving jurisdiction to decide the matter. Full stop. Next para, secondly, comma, insofar as the compliance of section 65 capital B is concerned, comma, although the said provision is a bar in taking evidence, comma, we do not find any reflection of the said of any objection being taken at the point of admissibility of the evidence. Full stop. Next para, it is further arguable as to how far the learned trial judge could pass a decree on the basis of printouts of emails, and also as to how far the defendant appellant objected to such material at the time of adduction of evidence, comma, in order to appreciate the issue conclusively. Full stop. We are also apprised on query that the defendant stroke appellant did not lead any independent evidence to disprove the case of the plaintiff. Full stop. Next para, thirdly, comma, regarding MSME, comma, we also do not find any point objection being raised by the defendant stroke appellant before the trial court, apart from in the written statement. Full stop. Next para, at best, comma, the same could be an error of law which is arguable at the time of hearing of the appeal, but does not amount to a patent perversity to come within the purview of the riders stipulated by the Honorable Supreme Court in Lifestyle Equities Supra. Full stop. Next para, undoubtedly, comma, such questions will be open to be decided in the appeal, full stop, but at the threshold, comma, we do not find any mitigating factor to waive the requirement of deposit of decretal amount as a condition of stay. Full stop. Next para, accordingly, there shall be stay of operation of the impugned judgment and decree and stroke or any execution case, comma, if levied in respect thereof, comma, till disposal of Can 1 of 2026, subject to the appellant depositing the decretal amount within bracket without interest, bracket closed, with the learned registrar general of this court within 4 weeks from date. Full stop. Next para, the stay shall continue unconditionally for 4 weeks, and thereafter, comma, upon such deposit being made, comma, the shall continue till disposal of the application. Full stop. In default, comma, however, comma, the stay order shall stand automatically vacated without further reference to the court after the expiry of 4 weeks from this date. Full stop. Next para, in the event such deposit is made, comma, the same shall be invested in a short-term interest-bearing account stroke deposit with any nationalized bank stroke institution by the learned registrar general and shall be subject to the outcome of the appeal. Full stop. Next para, the appellant shall serve a copy of Can 1 of 2026 on the respondent, indicating that the application shall be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellant.
Lord, we have already served. Lord, they have entered appearance. The appeal is otherwise ready for hearing. Lord, the endorsement is also there.
What is the defect deficit code you have put in?
That is defect removed. Lord, that endorsement is also there. As regards service, the appeal is ready. For the first, Lord.
Very well.
Lord, I filed the affidavit service.
Since from the office report dated August 11, 2026, it appears that the respondent has already entered appearance through its learned advocate, service of notice of the appeal on the respondent be dispensed with, and the appeal be treated to be ready as regards service, full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Lord, one more thing, Lord. The execution case number is money execution 1 of 2026. Lord, would your Lordship, Lord, indicate that, Lord?
And execution case if levied na bole they mentioned in the prayer all further proceedings in money execution case number 1 of
Lord, money execution case number 1 of 2026.
2026 pending before the which court?
Lord, same court, Lord, learned civil judge, senior division, first court at Uluberia, Howrah.
ওইটা execution case if levied এর বদলে ওটা।
Lord, one further indulgence, Lord.
Yes,
If, Lord, the time period may be extended to 8 weeks, Lord, instead of 4 weeks, Lord. I had prayed for, Lord, instead of cash security, any other, but your Lordship is
কোর্টটা 6 করুন। Great. Affidavit of service filed to be kept on.
obliged.
বলে দিন রিকোয়েস্ট ডিসিশন হবে তো
আপনি আছেন আমার সাথে?
বলেছি না ডেফিনেটলি গুড সাইড
Original copies if I
ভাবে দিতে হবে দেখেছেন পার্টটা yes
But I appear for the appellant.
for the previous item, if I may.
My lord, I beg.
take it yes
This is an appeal, my lord, against the final decree of partition. My lord, there are two applications. One is Can 1 is section 5 and another, my lord, Can 2 is, my lord, the stay.
what is the delay
My lord, 157 days. My lord, what happened, my lord? The order which was, my lord, challenged, my lord, earlier was in a civil revisional application. My learned friend, my lord, thought, my lord, acceptance of the, my lord, commissioner's report. My lord, that revisional application was withdrawn with liberty to file an appeal, and I was also given liberty to claim benefit under section 14 of the Limitation Act. If your lordship may kindly see, my lord, the order which is at, my lord, page 12 of the, my lord, section 5 application.
at liberty to pray for condonation of delay
Yes, I prayed for it.
you are praying for that
Yes,
that liberty was given without the liberty also you have that liberty
I have
the
prayed
judicial
150.
court cannot
No,
determine whether
that's
it's
only one
you have to
observation.
independently apply
Yes,
your
yes,
mind
yes,
yes when did you file the revision Mr. Bhattacharya
Lord, revisional copy টা আছে।
it's a should is
Lord, as
practicing for quite some time we have to see whether it's bona fide or not on the part of his client
the affirmation এর date টা বলো।
he's not a newcomer
It was my 30th January 2026.
30th January 2026. It was, my lord,
within limitation
No,
no, that was within limitation.
that was within limitation when was it withdrawn
My lord, it was 24th June 2026. It was
Fine.
running in the list, my lord. It was, the appeal has been filed on, my lord, 24th July 2026.
31st July the application is 31st July let us-
Application is, appeal is on 24th July.
24th July So, about 1 month after yes what do you say
My lord, page 14 of the application for condonation of delay, my lord. The solemn order passed by the Honorable Single Bench is 24 June 2026, my lord. And the second point raised by my learned friend's client is that the personal illness of the learned advocate, my lord. I am not
illness during which period between the revision being withdrawn
And
and
some-
the appeal
and
being filed?
some, my lord.
Declined.
Learned advocate, my lord, annexed page 15, my lord. And the page 15 of
What
the,
is the averment in the
No,
my
application?
lord, there is averment. I pick it up.
not advocate, my lord, the
Learned
applicant's
advocate,
improvement of the physical conditions
physical condition.
of the applicant,
No, no,
not
the
the
applicant remain, yes, my lord, the applicant, my lord,
applicant.
applicant.
Contacted
Paragraph 8, my lord,
8 and 9 also.
8 and 9.
This is the period between the revision being withdrawn and filing this appeal.
Yes, 13 June, revision was withdrawn on Millard
12.
24.
And
24
24 June.
24 June.
How does that matter? That is extra.
I have not, my lady, my lord's order, my lord.
The present appeal has been preferred after a delay of about
57.
157 days. Is of next parallel and counsel for the appellant argued submit that initially, due to a bona fide error, comma, a revisional application was filed under the impression that the order accepting the commissioner's report was to be challenged. Full stop. It may be noted that the said revision was filed within the limitation period for filing an appeal. Full stop. Next para. Subsequently, comma, however, comma, the it was detected that instead of filing a revisional application, comma, the appropriate remedy would be to prefer an appeal against the final partition decree accepting such commissioner's report, comma, whereupon the revisional application was withdrawn and the present appeal filed. Full stop. A time of about 1 month was lost in between the withdrawal of the revision and the present appeal. Full stop. In the interregnum, comma, the petitioner suffered from an ailment as well. Full stop. Next para. Learned counsel for the respondent opposes the prayer and points out to the delay between the filing of the revisional application, withdrawal of the revisional application and the filing of the appeal. Full stop. Next para. Upon a perusal of the amendments made in the application and the annexures thereto, comma, we are, comma, however, comma, satisfied that sufficient bona fide reason for the delay in preferring the appeal has been made out. Accordingly, can 1 of 2026 is allowed, thereby condoning the allowed on contest, thereby condoning the delay in preferring FAT 278 of 2026. The said appeal be deemed to stand registered and admitted. Can 2 is for stay.
Stay of operation, Millard.
My lord, to this, my lord, I may be permitted to file opposition, my lord, in opposition, my lord. And
No, you have asked for status quo.
yes, my lord.
Yes.
And they have admitted, my lord,
Stay as well as status quo. What do you want?
No, Millard, this has to be stated. Millard, first, Millard, if your lordship would kindly see, Millard, the preliminary, the final decree, Millard, dated, Millard, 19th November, Millard, 2025. Millard, I do not know.
You're granting stay as well as both parties, direct both parties to maintain status quo. Them also.
my
In the meantime, you
In
will
the meantime-
grant you time to file opposition. How soon can you file your opposition?
lord, 4 weeks, my lord. If your lordship kindly
And
sees,
one
my lord, order
week
number
for reply.
74 dated the impugned order, my lord, this is a second preliminary degree.
Exactly. So.
This is a second preliminary degree.
That is your ground.
Means, my lord, because, my lord,
That is one of the grounds.
when the advocate commissioner was doing his job, my lord, they did not participate. I only participated. And the learned trial court has given them liberty to participate afresh and to thereafter the final degree may be passed. If you also kindly sees, my lord, solemn order dated 19th November.
Twofold ground. This is one. Secondly, Millard, no,
And then-
no notice
Millard,
at all served upon them. No notice.
Millard,
If this is remanded, Millard, I can, Millard, again, Millard, participate in the Millard final degree proceedings before the commissioner.
That would be better, my lord. My lord,
Then
may,
this,
You're agreeing?
my lord.
exactly. They are the other defendants. We were never served. We
this one-
specifically put Millard question to cross examination to the partition commissioner. He said, I have served. But learned advocate in the trial court, Millard searched out entire Millard the trial court record. Not a single notice has been given.
Millard, my-
Only Millard their Millard client
Kindly
has
allow me
received.
to take instruction on this aspect because, my lord, the partition commissioner has depicted my portion of my
You
portion.
take instruction. You must have had instruction. You are saying that
No, my lord, just the application,
Already
two
says it.
applications were served upon me. these two
Only,
applications,
and
and
my lord, the final decree is even more surprising.
not have the
Only,
other
my lord, my
decrees.
landed friend share has been demarcated. My lord,
Because
the only
the
landed
child could
portion
also-
has been demarcated. The my lord, residential house, my lord, remains intact since it is in their occupation.
the learned advocate commissioner and the learned trial court have said that they have not participated in spite of service. That is a
So therefore, what do we do? Tell us. Then we are directing to file affidavit in opposition.
my lord.
From the memorandum of the appeal and the arguments of learned advocate for the appellant, we find certain arguable questions having been raised, such as whether any notice of final degree proceedings and commission work was at all served on the defendants.
I'm the plaintiff and the plaintiff.
On the
Defendant number,
on the plaintiff,
but I am defendant number 1,
on the plaintiff and the other defendant,
number 2 to 5.
and the defendant numbers 2 to 5. Full stop, next para. Moreover, learned counsel for the appellant points out that only the defendant number 1's defendant stroke respondent number 1's share has been partitioned and demarcated, allotting the lion's portion of the property to a lion's share and better portion of the property to
But
the
my 1/6 share, my lord.
respondent number 1. Full stop, next para. Such contentions are controverted by learned counsel for the respondent number 1. Full stop. However, learned counsel appealing for the respondent numbers 2 to 5 in principle supports the contention of the appellant. Full stop. Be that as it may, on the prayer of the respondent number 1, the respondent, you won't file an opposition. Respondent number 1 is directed to file affidavit in opposition to the to Can 2 of 2026 within 4 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The application shall next be listed for hearing on September 21, 2026. Full stop. There shall be stay of operation of the impugned decree till disposal of the application. Full stop. The parties shall also maintain status quo with regard to the suit property till disposal of the application bearing Can 2 of 2026. Full stop. Next para. In view of the appearance of all the respondents through their respective learned advocates, service of notice of the appeal on the respondents is dispensed with, and the appeal be treated to be ready as regards service. The appellant shall, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Affidavit of service filed to be kept on.
My lord, judgment dated 15 February 2023, my lord.
Sorry. Yes.
My lord, plaintiff opposite party has filed a suit for declaration and recovery of khas possession damages and also for permanent injunction on 22nd November 2013, my lord, against the Badar, plot number 19, in respect of 2 rooms situated in the extreme western side on the ground floor and first floor, my lord.
On the ground that you are a trespasser.
Yes, yes, yes. Badar, my lord. My lord, second page of the judgment, my lord, kindly see. Only point, my lord. Respondent plaintiff issues title suit for declaration of his right, title, and interest possession over the civil property after evicting the appellant, defendant along with a pair of permanent injunction and for khas possession of the suit property.
What is your ground in the appeal?
My lord, kindly. Defendant file an application for adjournment of the ground of physical illness along with the medical certificate, and the appellant medical certificate was disbelieved, and the adjournment petition was rejected, and the suit was posted for argument without providing an opportunity of appellant defendant adduce evidence, my lord.
Did you challenge that order?
No, my lord. My lord, trial court has also this point is arised, my lord. I filed the appeal, my lord. Same.
This is not a substantial question of law. This is a second appeal.
Yes, yes. First degree is obtained by the Defendant, my lord. I challenge this order. I filed this appeal, my lord, before the
First degree obtained not by the defendant, by the plaintiff.
Hmm.
Plaintiff got a degree of eviction. This is a judgment of affirmance. Both the courts have
yes, yes,
decided against you.
yes, yes, my lord.
So where is the substantial question of law in this? Your medical certificate was disbelieved by both the courts. Trial court
Well,
disbelieved. Appeal court affirmed that.
No, yes, my lord. I page, my lord.
What is the substantial question of law?
My lord. Only
Let alone substantial. What is the question of law?
my, he has not adduced any evidence, my lord, defendant. my
Yes, because you did not appear and your adjournment was refused by the trial court.
lord. Medical certificate is produced, my lord.
Yes, that's a factual appreciation of evidence. Entirely question of fact. The provisions in this code of civil procedure has a meaning.
My lord,
It's like a pyramid. It goes up, it tapers off. In the second appeal, you cannot reopen everything which you could before the first appellate court. We could have, before the first appellate court, we could have considered this. This is the second appeal.
Yes, yes, my lord. My lord,
First appeal is for all practical purposes, first appeal is the last rung you have, in fact, on facts and on law. Second appeal, if substantial question of law is involved, no question of law we find here. You are, if you had simplicity are precluded from adducing evidence, we could have understood. Adjournment filed, disbelieved.
my lord, only count of physical
Second
illness,
appeal
my
is not a mercy jurisdiction of the High Court. Second
Well,
appeal, you have to clearly prove a substantial question.
lord. Actually, the property is a joint property, my lord. Can you see?
These were disbelieved. These are factual evidence is there. Both courts came to a particular conclusion. What is this is the only question of law. This is not a question of law. Sorry.
My second point হচ্ছে joint property, my lord. Here, kindly see. Eligible, my lord. Kindly see. First judgment, my lord, have been positionally dependent on other brothers.
What are you placing?
Eligible property.
Which page? Where?
Page, my lord, first judgment, my lord.
Trial court's judgment.
Calcutta.
Which page of trial court's
Yes,
judgment?
yes, my lord.
Refer to the internal pages.
35, 36, 37.
Internal.
Uh,
At the top.
25.
Printed.
Case of the defendant.
Which page?
Oh, page, my lord, now, my lord, my page is 37, my lord.
At the top printed number is there.
Page 4.
Okay, Babu.
Printed number, page 4. Page 4, my lord.
Yes. Continue.
মানে defendant further state there
This is a defendant's case. So
yes, the rest 2 decimal of the land has been purchased in the name of the Shankar Singh, Pratap Singh, and in the name of the plaintiff, and in the name of since then the whole properties, the plot numbers have been positioned dependent on the property is Rejmal.
what is your title to the property?
মানে plaintiff has purchased the
Your pleading is that at the time the plaintiff was completely dependent. It's written defendant should be dependent upon his father and he had no income.
yes, my lord.
Therefore, suit property cannot be personal property. This is entirely based on conjecture. Entirely based on conjecture.
My lord,
Registered sale deed has been produced. It has a presumption of correctness.
he has
He could not rebut it.
my lord, he has purchased the 6 decimal, but the appellant has purchased the 2 decimal, same plot, my lord.
This
Undivided.
decree was the decree was passed in respect of their portion, their purchase portion.
Undivided portion. Joint.
Where is this point discussed by the trial court? Let us see where you have taken this point. What is the discussion on this? What is the issue on this first? Internal-
11, my lord.
Internal page 9 come there. Second paragraph, it also appears.
9, yes. It also appears that
There was a
case
previous-
record that the subsequent plaintiff filed.
Previous decree was also there.
Yes, yes.
So why are you suppressing that? What was the previous decree?
Judgment degree such and such, but has been marked as an exhibit. It appears when the court most vital documents evidence suit because it is a preliminary degree of the partition suit filed by
Then-
the present defendant and other against the judgment or other plot number 9 is
Your
under.
partition suit was preliminary degree was passed. Shares were separately declared. Partition degree, no final degree was passed in the partition suit.
No. And page 11, my lord, kindly see.
Page 11, yes.
Now, from the above discussion, above deciding the issue, it appears before the court that the plaintiff has successfully provided the own case by erasing proper documents.
This
as
is
well.
unimportant.
Yes.
We are looking at the main core issue and you are একটু dubious লাগছে না মানে বলছে এক্সিবিট যেটা করেছে সেটা হচ্ছে প্রিলিমিনারি ডিক্লেয়ার পার্টিশন সেটা শেয়ার ডিক্লেয়ার তাই তো শেয়ার ধর ডিক্লেয়ার হলো now as significant specifically held that Calcutta was under exclusive ownership. Did he hold the exclusive ownership preliminary decree without partition? সেটা তো ওর এক্সক্লুসিভ বলা যায় partition to exclusive হচ্ছে না ওটা on behalf of all the issuers ফাইনাল ডিগ্রি কোথাও এক্সিবিট করে judgment is a plaintiff is not capable to get any relief in respect of 40 plots. No, but the trial court also held in the preliminary decree, please come to page 9 again, within inverted comma that italics. Plaintiff, you are the plaintiff there.
Yes, my lord, I'm the plaintiff.
Plaintiff is not entitled to get any relief in respect of 40 plots mentioned in item 2 and in respect of 4 kata land purchased in the name of Vijay Singora. So
Yes.
those were exclusively purchased by him, those plots, and therefore those did not come within the hotspot that was held in the preliminary decree. That you don't have any title to those plots. Apart from the others, preliminary decree was passed. So therefore, it was that decree has attained finality. That was excluded from the hotspot of the common property. The trial court has relied on this specifically.
Yes, 4 kata land purchased in the name of the Vijay Singora.
Within the italics, within the inverted comma italics, page para 3, page 13, specific reference.
Yes.
Plaintiff is not entitled to get any relief in respect of 40. So in the partition suit, you are held not to get any relief in respect of 40 plots mentioned in item 2 and in respect of 4 kata land purchased in the name of Vijay Singora. Vijay Singora must be the other side.
Yes, ma'am. Dependent.
So therefore,
Plaintiff
that was held, that has attained finality on the basis of that this decree has been passed. So that was kept outside the hotspot of that joint property, even by the previous decree. No. Sorry. In the present second appeal, comma, a judgment of affirmance whereby a decree of eviction and consequential reliefs was passed against the appellant has been challenged. For the next para, learned counsel for the appellant makes twofold submissions. For the first, comma, that despite having filed an adjournment application in the trial court along with sufficient medical documents, comma, such adjournment was refused and the defendant stroke appellant was precluded from adducing evidence, thus affecting the valuable rights of the appellant. Whose of next para, secondly, comma, it is argued that although a preliminary decree was passed in a previous partition suit instituted by the defendant stroke appellant between the same parties, comma, no final decree of partition having been passed therein, comma, the subject property remained joint, and as such, every co-sharer had right over every inch of the property. Which of thus, comma, it is argued that the learned courts below erred in law in decreeing eviction of the appellant from specific portion of the said joint property. Which of next para, however, comma, insofar as rejection of the adjournment application is concerned, comma, both the courts have factually been satisfied that such rejection of adjournment was justified, and consequentially, comma, the second appellate court cannot reopen the preclusion of the appellant from adducing evidence on such ground. Which of next para, insofar as the second ground is concerned, comma, at page 9 of the trial court's judgment, the learned trial judge specifically took into consideration the certified copies of the judgment and decree of title suit 131 of 2004 passed by the learned civil judge senior division at Burdwan, which was marked as exhibit 6 series. On perusal of the said documents, the learned trial judge specifically held that the earlier court, hearing the partition suit, granted preliminary decree and specifically held that 4 kathas of land in plot number 90 were under exclusive ownership of Bijoy Kumar Singh Roy, that is the present plaintiff stroke respondent. Full stop.
Submission, my lord.
It was further recorded that the plaintiff therein, bracket present defendant stroke appellant, bracket closed, was not entitled to get any relief in respect of 40 plots mentioned in item 2 and in respect of 4 kata land purchased in the name of Bijoy Singh Roy. Full stop. Next para, we find from the present impugned decree that it is plot number 90 in respect of which the decree has been passed. Thus, even from the findings of the courts below, it is evident that the issue of alleged title of the parties in respect of the suit plot has already been conclusively decided, which operates as res judicata. The earlier preliminary decree having conclusively held that the present appellant was not entitled to get any relief in respect of the subject plot, which was thus kept outside the hodgepodge of the said partition suit, insofar as joint properties are concerned, there was no illegality on the part of the courts below, learned courts below, in decreeing the present eviction suit on the finding that the plaintiff stroke respondent was the exclusive owner of the property. Accordingly, we do not find any substantial question of law involved. Hence, Essay 15 of 2026 is dismissed under Order of Attorney Rule 11 of the Code of Civil Procedure. Consequently, Can 1 of 2025 stands dismissed as well. No orders to cause urgency. Yes, what were you saying?
On the basis of degree, my lord, I filed a second appeal, my lord. The case is pending.
Yes, next.
May I please your lordship? Defendant is the lord appellant before your lordship put for lord eviction of licensee and the judgment of affirmance both the learned court decreed in favor of the plaintiff. Now, lord, the plaintiff's case was that she, lord, being the owner of the suit schedule property, allowed the original defendant, her nephew, to reside in the suit schedule property for 3 days. Now, even after expiry of 3 years, since he did not leave the property, the suit has been filed for eviction of license.
You are the nephew.
I'm the heirs of the nephew now. Now, the defendant case was that he was not licensee but tenant, and supporting in support of his contention, he has produced some documents, including the rent receipts. Some other identity cards and other has been produced, and rent receipt has been produced.
Issued by whom? Her.
Her. Now, rent receipt was tendered at the time of evidence of the plaintiff. She refused the execution of that rent receipt. Probably that has not been exhibited. That is why at our instance, the handwriting expert was appointed. When the handwriting expert submitted its report in the court, then they have come with an application for amendment of the plaint. 2 amendments has been sought. One is during the existence of the licensee, the defendant compelled her to put her LTI in some blank papers, and that has been converted to different. And second is he sought to introduce 2G. Since during pendency 5 years lapsed, defendant has expired, so heirs are not entitled to reside there. Now, however, the learned trial judge, the first court, decided the suit in favor of the plaintiff on twofold grounds. One is, my lord, although Ford rain receipt has been produced by the defendant, but that has not been proved by the defendant. And second is, my lord, during the pendency of the suit, the defendant did not show his bona fide and deposit the rent in the court below to show his bona fide as a tenant.
Obviously, second ground is
And
passed for your client, for the benefit of your client. Second
And-
direction.
yes, and my lord, the appeal court, my lord, went further. Appeal court says plaintiff failed to prove the licensee and defendant also failed to prove the tenancy. And my lord say
No, if that is
affirm
so,
the decree.
if that is so, Mr. Bonik, then you have to prove your status. That's settled.
Your lordship kindly see, I might produce, but my lord,
Rent receipt.
the rent receipt,
Rent receipts were
the
not exhibited.
RTI was approved by the handwriting expert. That
Rent
is the
receipt was
signature.
not exhibited.
Yes, the RTI has been exhibited. Rent receipt has not been exhibited. Your lordship kindly have a look to page 60.
Rent
Yes.
receipt not exhibited. The
The RTI left thumb impression of the
L,
plaintiff.
R is right. You said RTI.
Sorry, my lord, LTI.
RTI is something else.
No,
So
your
LTI
lordship,
was exhibited.
LTI only exhibited as Exhibit E.
But the rent receipt itself was not
No.
exhibited.
And that is the ground, my lord. The rent receipt was issued in Hindi and Urdu language. Your lordship kindly come to page 59 once. The trial court observation.
Yes.
The bottom sentence, my lord. Now there must be an agreement, oral if not written, a starting point, a tenure and fixed settled rent of any tenancy. Defendant has not adduced even a single oral testimony of such relationship. Let one documentary evidence of the agreement of the purported tenancy. In this instant case, although the defendant had submitted 4 kacha rent receipt in support of his contention that he was a tenant under the plaintiff, and at the time of argument had also mentioned that the receipt which is written in Hindi, that is the rent receipt of January 97 to October 97, but he had failed to substantiate his such claim by bringing to cogent and trustworthy evidence before the court. No one can be a tenant since ever. The question of agreement and beginning of tenancy is answered against the defendant. In the instance suit, there is no explanation offered as to non-production of regular rent receipts from the beginning of tenancy, which itself has not been mentioned. And although at the time of cross-examination of DW2, it had been stated that there may be other kacha receipts in their custody, but they failed to produce the same before the court. In addition to everything discussed herein before, during all these years that the suit is pending, defendant has had made no attempt to establish his possession as a statutory monthly tenant over the suit scheduled property by depositing the monthly rent payable, whatsoever it may be, in court, even if the plaintiffs were refusing to accept the same. Everything aside, this itself is sufficient to establish the truth with respect to defendant's claim of being statutory monthly tenant of the plaintiffs over the suit property. This is not the how the landed trial judge adjudicated the issue number 4, whether defendant is
How did
licensed.
the appeal court
Your lordship, can you see the appeal court?
page 6
Yes,
decision with you.
page, my lord, 50. Page, my lord, 10. This is, my lord, the issue number 4. This is the bottom portion of paragraph number 11, where the issue number 4 has been discussed. To sum up, the 10, my lord, first 3 line, page 10 of appeal court judgment. To sum, has the lordship got? To sum up the above discussions in the foregoing paras, it appears that the plaintiff in this suit has failed to prove that the original defendant was a licensee in the suit scheduled property. On the other hand, the defendants have also failed to prove their predecessor was a tenant in the suit property under the plaintiff. This court is of the view that the determination of the learned trial court of this issue to be in favor of the plaintiff without explicitly deciding whether the defendant was a licensee or tenant is very fit of reason. The said issue is, however, now left inconclusive due to the aforesaid reason.
Even if the plaintiff does not prove induction as licensee, you have to prove your status. Mr. Boni, please come to page 9 of the appeal.
Yes.
That is more crucial. Now coming to the evidence.
Now coming to the evidence.
So forget the first electricity connection part.
Yes, yes.
Skip over first 7-8 lines.
Yes.
DW1, however, further produced.
DW1, however, further
Please place that
produced
portion. Yes.
4 months rent receipt in support of the case of the defendants, and that their predecessor was a tenant in the suit premises, although the contents of the said rent receipts have not been proved in this suit. The LTI of the plaintiff over them have been proved by a fingerprint expert, Mrityunjay Roy, who deposed in this case as DW2 and proved his print report and other documents which was marked Exhibit 1 series. Upon such proof of his report, in which it is mentioned that the respective LTIs on the 4 rent receipts are found identical with the specimen of LTI of the plaintiff Jamila Khatun, the LTI of the plaintiff over the 4 rent receipts have been
So
marked.
plaintiff's LTI was proved.
Yes, LTI has been proved as marked as Exhibit E.
Yes, but court proceeds further. It is
Yes,
clear.
it is clear that the rent receipt have not been marked Exhibit.
That is
as
what
a
we also
whole.
asked you.
Yes, but only the LTI of the plaintiff of them have been marked Exhibit. The witness in the said documents has not appeared before the witness box to corroborate its contents. The endorsements over the said receipt have not been proved, due to which it cannot be ascertained whether the said documents are indeed rent receipt issued by the plaintiff in the name of Mohammed Rashid with respect to the suit property. The proof of the LTI of the plaintiff over the said document does not go.
Court is correct, Mr. Bonik. You did not
So,
prove the
Lordship,
contents of the.
kindly visualize this thing. Our case was in written statement specific that she has issued some rent receipt and allowed.
You produced the documents. After
Document
that
has
you
been
did.
produced.
After
When
that
she,
you did.
yes,
Then you proved the LTI also that it was her LTI. But
since she refused at the time of Milord,
ultimately it was proved.
It was
her
proved.
LTI.
It was proved.
But the contents, in the absence of the contents being proved, Mr.
So
Boni,
far as the Milord,
content, the author, either not the author, maybe someone else had to prove that this is a rent receipt issued to me,
yes,
or something like that, issued to you. That was never proved. The contents having not gone,
the
how can
rent
the court
receipt
even
was
rely on-
issued in Hindi and Urdu language.
So
That
Hindi and
is-
Urdu are not foreign languages.
That is, Milord, that is the thing, Milord, that
What is the thing?
that objection has been.
No, the contents had to be proved by somebody. The rent receipts here have not been marked as that is the first thing we asked you. That's
Yes.
why the rent receipts themselves have not been marked. Even if a particular signature or LTI is marked, that signature goes.
Yes.
It is at best established, but whether that was actually a rent receipt issued by her for this property or these, no, the contents having not been proved, how can he know that these were
That
rent
has
receipts
not
for
been.
this
Your
property?
Lordship, kindly see.
Might have been something else.
Yes, this is the Milord.
Contents cannot be looked into.
The
Rent receipts were
exhibit
not marked.
before exhibiting this document, Milord, that has been produced to that has been tendered or that has been shown to the plaintiff to mark it as an exhibit. When she refused, the handwriting expert application was filed.
That was regarding the LTI. Now, Mr. Bonik, the main documents.
Entire, Milord, entire, not only LTI. If she admits that this is the document and this is my signature signed by me, Your Lordship, kindly visualize this thing. Rent receipt is, Milord.
You have to prove independently the content of the. Look, the appeal court's finding is that only the LTI, that is the ground, which is we find correct, because the document independently had to be proved by one of your witnesses. You could have done a recall of your witness or some other witness who would come and say that yes, this is the rent receipt issued for this premises.
Evidence to offer. That probably, Milord, that has been stated, Milord. What evidence to offer?
Show us the evidence, yes.
Yes. No, later. Your Lordship, kindly give me 1 day time. So that
Come back tomorrow.
Monday.
Not tomorrow, this month.
Monday.
During arguments, it transpires that the evidence of the parties acquires relevance. First up, in order to enable learned counsel for the appellants to produce copies of the same, the matter is adjourned for the day. Mr. Bonik, please bring
yes.
possible 2 copies. Even if not possible, 2 copies. 2 copies have to be.
Obviously, 2 copies, Milord.
Yes. Two copies for us and one for you also.
Yes.
Unless you have it by heart. Yes.
Item number 7 with 8.
Not appear for the appellant.
Appear for the respondent, Lordship.
Yes, Mr. Ward.
Milord, service of both the appeals, Milord. The first appeal is against the parent order, Milord, and the appeal next in line is the order.
Both are appearing before us.
Both are appearing. Milord, the parent appeal, Milord.
Second one is against the extension.
Extension. Milord, the parent appeal challenges of propriety, Milord, of an ad interim order passed in section 9.
Which one is that?
That
We'll look
would
into
be,
that
Milord,
first. FM 887, FM 8241.
No, that's the first one.
Yes.
Milord, it is, Milord, that challenges the propriety of an ad interim order, Milord, passed in a section 9 proceeding, section under the arbitration conciliation. Milord, kindly takes the impugned order for once. Milord, I am the opposite party number 3. Milord, before the court below. See the impugned order, Milord, 20th of June 2026. This is a petition under section 9 of the Arbitration Conciliation Act filed by the petitioner with prayer to direct the OP to allow the petitioner to continue the catering services in train number such and such, as because on the basis of notice dated such and such, 5/5/2026, Ministry of Railway restrained OP and their men and agent from handing over, transferring, assigning, or creating third-party interest in respect of the said train. He further prayed for an order of ad interim injunction to that effect. No caveat heard.
For the IRCTC.
3.
Do
He also submitted.
know where you go during the recess then?
But we don't get to sit. That's the problem.
Maybe provided with sofas and all inside. How do you know?
Yes,
we don't get to see you sit.
I'll leave it that.
Anyway, so tender, yes. After heard.
Then, he also submitted as petitioner applied for tender of catering work in respect of the said train, which was floated being tender number such and such. Deposit earnest money to the tune of such and such. According tender of this petitioner was accepted, and he was allotted the said work. But vide notice dated 5/5/2026, Railway ordered and restrained the petitioner from said service. Hence, he filed the miscase with a prayer to restrain Railway from such illegal act for a period of at least 4 months. On perusal of the agreement in question, I find that this petitioner was allotted tender of catering work in the said train, but without assigning any reason under the force majeure clause. He was asked not to carry on the said business. Hence, I find prima facie case in favor of the petitioner. If the same is not be allowed, he'll suffer loss, ad interim order. Now, Milord, kindly looks at, Milord, what was this letter which is referred to on Milord 5th of May. That would appear at page 148. Of the CAN application, Milord, being volume 2.
Must have been a part of their section 9.
Yes, the part of the section 9. Page 148. The cases, Milord, we have restrained them. Milord, kindly seize. Kindly seize page 148. Milord, this is the notice they refer to. Ministry of Finance, Department of Expenditure, video OM dated under reference number such and such issued instruction regarding force majeure clause. The same is being circulated herewith for information necessary action. Now, Milord, seize the next page 150 is the office memorandum.
Yes.
Subject force majeure clause FMC. Attention is invited to para 9.3.6 of the Manual for Procurement of Goods, 2024, para 10.4.9 for the Manual of Procurement Consultancy Services, para 9.4.10 of the Manual for Procurement Non-Consulting Services, and para 7.4.4 of the Manual for Procurement of Works, 2025, issued by the department, which is reproduced under. Kindly seize, Milord, paragraph 2. Attention is also drawn to paragraph such and such. Again, Milord, the same thing. Then the last 2 lines, Milord, the referred manuals recognize delays in delivery of completion of contractual obligations on account of force majeure event for which the supplier, consultant, service provider and contractor is not at fault. Then Mulad kindly comes to Mulad paragraph 4. In such an event, date for completion of contractual obligations which had to be completed on or after February 28, 2026 may be extended for a period of not less than 2 months and not more than 4 months without imposition of any cost or penalty for the contractor. But there's no question of any restraint. And Mulad, the next issue which is important is, it's in respect of contracts where contractual obligations had to be completed on or after 28th February 2026. So if a contract had been terminated prior thereto, or if a contract is not in existence prior thereto, this office memorandum will not have any manner of application.
No, there is no other communication of that date.
No, but this is the basis on which
this is an annexure to their section.
Yes. Kindly sees, I read out in interim order 5.5.
Sure, there is no other 5.5 communication.
Let us have it from the respondent themselves.
So what is your submission? Complete submission.
So any contract which has ended or terminated prior to 28th February will not have any manner of application.
Their contract terminated when, as per them?
16th of February, and I'll show it from records,
No, they admit that.
I'll show it from the records. Now kindly comes to their application. At page 40, I'll be placing the application, but prior thereto, the prayer at page 48. What is the reason for this? The reason would be apparent from the prayer itself. What exactly do they want to achieve? This would be page 48, which is the prayer. Injunction be passed directing the opposite party to allow the petitioner to continue the catering services in train number such and such for a period of 4 months on the basis of the notice dated 5th May 2026 issued by the Ministry of Railway Board. Then, and or an order of injunction be passed restraining the opposite party, their men, agents and associates from handing over, transferring, assigning and or creating any third party interest in respect of train number such and such. So that is the primary prayer. Then kindly now takes the application. Now that would be at page 40. It starts from page 40. Admittedly, the initial master license was dated 5th of March 2014 for a period of 5 years. That's an admitted position. Now kindly sees. I'll be straight away coming to paragraph 7.
Yes.
The letter of award dated 31st January 2014, your petitioner duly accepted the said tender within the time mentioned and the said award, and the petitioner also paid the license fee for 5 years and also deposited security deposit in the award letter within time. So first 5 years. Then kindly comes to paragraph 10. The petitioner states that after successful completion of 5 years, the opposite party was extended the said contract for a further period of 5 years by the letter dated 30th December 2019 on the terms and conditions contained in the said letter, and the petitioner duly paid the license fee and security deposit as required under the said renewal letter dated 30th December 2019. This is the first extension. Your petitioner states that before February 2017, the railway services in mobile trains were managed and supervised by the railways. Notification by the railways to transfer the entire catering services to the IRCTC. So 1 and 2 are the railways, they are the parties in the section 9, 3 is IRCTC. Then kindly sees your petitioner, paragraph 12. Your petitioner states that due to the COVID pandemic 2019, the supply of cooked food in mobile trains was temporarily stopped. And thereafter, supply of cooked food in mobile train services was started in March 2022. As per policy of the opposite party allowed, all the license discontinue this non-period for a period of 2 years as dias non-period, and the petitioner also gets the extension of the contract dias non-period from 29/12/2016 to 16/2/2026 in respect of the said train. What happened was in the COVID period, since the trains were not running, a subsequent agreement was entered into for which they were granted extension. So the extension comes to an end on 16/2/2026. The office memorandum says contracts on which are subsisting as on 20th of February 2026 would be governed by that.
But he says extended from time to time.
Kindly cease. Your petitioner states that after expiry of said period, the opposite party from time to time extended the said contract, the said contract is in force. No documents. So, bare submission. 10, that your petitioner states that the opposite party issued a fresh tender in respect of the said trains during existence of the present contract, and the said new tender was opened on 22/2/2024. As such, petitioner apprehends that the said trains, if handed over to a third party and if the opposite party is successful in the ulterior motive, your petitioner will be suffered. The petitioner participated in the tender. So, Mulad, a tender was open. Yes, Mulad. Mulad, this is factually covered. 2022. But after having participated in the tender, Mulad,
They participated in the tender obviously prior to Section 9.
yes,
Section 9 is
2022. 4 years prior there to Mulad.
কমিউনিকেশন ওইটা তো খবর হচ্ছে টেন্ডারটা কিছু কথা তুমি they did not come out successfully in the tender.
In fact, Mulad, your lordship's earlier order, there's another order passed in earlier proceeding. Records such a fact. Same thing, Mulad. 2022 tender, having participated, remained unsuccessful, they come in 2026.
It is settled down more or less. If you participate in the tender and then you cannot come,
And that's after 4 years.
you can challenge subsequently the modalities in which it was done,
Yes.
but not the fact of the calling of the tender or the premise of it.
I'm grateful, Mulad. Now the issue is, Mulad, let me take it a little further, Mulad. This is a paragraph, Mulad, paragraph 15. Kindly cease. Petitioner states the opposite party from time to time issued travelling authority in favor of the petitioner for supply of catering services in the said train. And lastly, opposite party VDAT later dated 16 June 2026 issued the travelling authority in favor of the petitioner for supply of catering services in the said train for the period 17 June to 19 June. This is something which I should be very clear and candid. What happens is this: prior to this, Mulad, they file another Section 9 application, get an interim order. That order was vacated. Mulad, we prefer an appeal. There's an order, Mulad, annexed to this. Mulad, these are points of suppression. After Mulad, my lord has referred that Bengal Mulad, club to the larger bench, Mulad, probably I'll be not able to take those, canvass those issues, Mulad. But the fact remains that this is, Mulad, pursuant to orders passed in the earlier miss case. Because since the earlier miss case, the interim orders were subsisting, Mulad, I had to do this. Otherwise, I would have been hauled up for contempt. So, Mulad, the issue now today is paragraph 17 and paragraph 16, Mulad.
A separate identity injunction application was filed.
No. The new Section 9.
No, in the Section 9 also.
No, one
Ordering portion says prayer for identity injunction in petition under is allowed.
Well, this is basically the same petition
Prayer is allowed.
regarding had to the fact ad interim order.
All right.
So this is what now going to kindly see paragraph 16. Petitioner states Ministry of Railway Board such and such, dated 5th, notification such and such, intimated the all general manager of Indian Railway and has issued instructions regarding force majeure clause on the basis of notification published by the Ministry of Finance, Government of India, dated 29th April, wherein it is clearly mentioned date of completion of contractual obligations.
The respondent is appearing, the private respondent?
Yes, they're appearing.
Yeah, for this.
Mulad, so this is the same notification, Mulad, I was referring to. Mulad asked whether this is the same notification or not. Kindly see, Mulad, which had to be completed, they also admit the fact, which had to be completed on or after 28th February. So in view of this averment and assertion, Mulad, I say that the notification of 5th of May 2026 doesn't have any manner of application insofar as the case of it hadn't concerned, my lord.
But 5th of May 2026, that notice, there is no notice
It's a
restraining him from
notification.
doing anything.
No, no,
If that notice, that notification applies, it applies.
it applies. Now, my lord, the most important issue, the issue is not this, my lord. What they circuitously want is, my lord, the second portion of the order which they are seeking.
Yes, because they have failed in the tender and then.
Now, my lord, most importantly, now they have annexed the license agreement as well.
Notification effective actually stay করে দেওয়ার চেষ্টা করছে নোটিফিকেশনটা স্পেসিফিক 20 to 20 এটা তো ওকে কিছু রেস্ট্রিক্ট করবে তো কিছু নোটিস ওই নোটিস ডেটেড সার্চেস সে ওয়াজ রেস্ট্রিক্ট কোথায় রেস্ট্রিক্ট করবে রেস্ট্রিক্ট করে এটা তো সে চাইতে পারে হচ্ছে ওটাই শুধু ওর কাজের কথা থেকে চলে ও চায় না সেটা একটা হচ্ছে প্রথম একটা নোটিশ করে 55 নোটিশ করে মামলা করেছে 55 নোটিশে নোটিশ তাহলে জেনারেল নোটিফিকেশনটাকে অ্যাপ্লাই করছে হ্যাঁ সেটাকে ভাবছি তুমি ওর উপর স্টেট করার চেষ্টা করছো যে করো পরীক্ষার অপেক্ষা সেকেন্ড এই যে কন্টিনিউয়াস অফ কন্ট্রাক্ট ভেগ তারা কিন্তু সব স্পেসিফিক ভেগ সবচেয়ে ইম্পর্টেন্ট হচ্ছে সাবজেক্ট কন্ট্রাক্ট টু পার্টিসিপেট অথরিটি অফ দ্য রেসপন্ডেন্টস টু ইস্যু such as participate to tender the floating হ্যাঁ সেটাই সেটাই বলছি পার্টিসিপেট করছে অন্য লোক কিছু সেকশন নেই এটা ভেগ বলছি এটা বলছি তো very good. Yes. Anything?
Now, my lord, paragraph 17. Petitioner states present contract contained force majeure and the opposite party also implied force majeure clause on the basis of notification dated such and such. As such, the present contract is to be extended for a period of 4 months after its expiry on 19th June. Then, my lord, para 20. Your petitioner states that petitioner earlier filed a missed case to the learned court on different grounds that had to be withdrawn. Then, my lord,
which paragraph?
This is para 20, my lord.
Oh, yes.
So earlier missed case is mentioned, and therefore, my lord, I will be relying on the contents thereof. Then, my lord, para 21, petitioner is entitled to get the extension of 4 months by implication of force majeure clause by Government India as well Ministry of Railway due to unrest situation. Then, my lord, para 24, 16.6, petitioner visited the office of the opposite party at Calcutta with a request to extend for 4 months. Then, my lord,
no, force majeure due to the Hormuz problem.
Yes.
Unrest situation in other countries.
Yes, Hormuz, yes, Hormuz. 28th of February. Now, contract terminates on 16th. And, my lord, that the contract terminates on 16th, my lord would kindly seize page
That's
1.
Not exactly a force majeure. It's a force majeure.
Major.
By the major.
Very major. My lord, page 145, kindly seize. Let's kindly see the first paragraph. This is the mention that Mr. Sunshine's caterers, page 145.
Yes.
Kindly see the last line of the first paragraph. Further extended to 16/2/2026, including dias-non period. So, the contract and the extension comes to an end on 16th of February.
This is the last document of extension they have filed.
So, the contract comes to an end on 16th. So, 5th of May, notification has no manner of application. And, my lord, kindly now takes, my lord, they had referred to earlier missed case. They sought to withdraw it. Now, my lord, they sought to withdraw it when we challenged the propriety of the interim order passed there and before this honorable court. Now that order, my lord, would be at page 399.
They have not pleaded earlier withdrawal was accompanied by a leave to.
No, they have not said that. But since they have said the earlier miscase was filed,
This case on self-same relief.
yes, those were in respect of 5 trains. My lord, one of them was this train. And will now seize the order passed by your lordship's court, my lord, at page 399. This is not a part of their application, my lord, but since they have referred to the miscase, I believe, my lord, that I can refer to this. Kindly takes up, my lord, page 399. When they sought to withdraw the matter before the learned before the learned court, my lord, the court was apprised of the suppression. Once, and that application for withdrawal happened after we filed the appeal. Now, when we move the appeal, kindly sees at page 399, this would volume 3. Learned counsel for the appellants hands over a copy of an order dated July 2, 2026, passed in connection with an application under section 9 and ad interim passed assailed in the present appeal. From the said order and as per submission of the learned counsel for the appellant, it transpires that the petitioner respondent in section 9 miscellaneous case such and such, subsequent to the passing of the intermediate order, sought to withdraw such application but was not permitted to do so in view of serious allegations raised therein. Because we had said that this order was obtained by practicing fraud on court. Then, my lord, your lordship, my lord, was pleased to dispose of this appeal on the ground that it became infructuous. So, my lord, this is the conduct. Page 397. And my lord, the application pursuant to which this order was passed by the learned judge in the court below appears at page 397. This was after we had preferred the appeal. So, my lord, I say, my lord, the impugned order, my lord, is perverse, my lord. If one word which I could describe it is perversity. And the subsequent appeal is an extension of that.
We'll come back and hear you. We'll come back and hear you. Yes.
Now, there's one further issue, my lord. Page 126. The jurisdiction is the courts at Patna. This is a part of the master license agreement, my lord, page 126, clause 21.4.
No, section 42, previous application before this court.
But that was dismissed.
Even then, filed. Yes.
Lordship kindly comes to my letter of renewal, which is at page 137. My contract was for 5 years, 2014, Lordship. It expires in 2019. By this letter,
Yes.
my contract was extended till 28th February 2024. They publish a 10-day floater tender on 22nd February 2024. I participate, I fail. Be that as it may, Lordship. Thereafter, the dies non period was for 2 years, which expires on 16th February 2024, Your Lordship. Kindly. Huh? 2026, I'm sorry, 16th February 2026. Kindly comes to page 144 onwards. 140. Which are the page numbers? 8 or 9? 8. 144, Lordship. These are the travelling authorities, Lordship. Here, Lordship kindly sees first paragraph, last sentence. The contract was renewed for the period from 1/3/2019 to 28th February 2024.
Last date is 16th of February.
16th of
Next
February.
page also same.
Yes. Continuously, the
Yes.
travelling authorities goes on. Till 146 page. It is issued till 16th February 2020.
So what is the point?
My point is, Lordship, I write a remand notice, which is 12th June 2026. I write where I have written that my kindly comes to that
Have you
remand
referred to
notice
that in your
153.
section 9?
Yes, Your Lordship.
Achha.
153, where I write that my contract. Lordship has got it?
Yes.
Lordship, the first paragraph, fourth last line, Lordship. The last sentence starts from since the present contract is valid up to 19/6/2026 and our case is squarely covered for consideration of extension under the said force majeure instructions. We have this. So, Lordship,
That is a
before
unilateral statement. There is no document to
Lordship,
support it.
I will, Lordship. I have obtained, thereafter comes to another travelling authority, Lordship, which is at page 152.
Yes.
My travelling authority kindly comes to the second paragraph. Further.
We have seen it.
Yes. And my impugned order is on 20th June 2026. So all this extension was given before I have come up before under section 9, Lordship. So it was not influenced by that order. They were forced to issue the travelling authority. So by this travelling authority, and by, I do not know what is this reference is from. I need to take instruction, Lordship, or it is their inter-party document. They can also produce. We were requested to issue travels. Who requested? Nobody knows, Lordship. But in my demand notice, I was already aware of the fact that till 19/6/2026, my tender was extended. So if we consider the notification, Lordship, it is on or after 28th February 2026. Therefore, I am eligible to get the extension under the force majeure clause.
But merely by giving you a travelling authority, does it mean that the contract was automatically extended?
Lordship, doesn't it create an estoppel, Lordship? Because I was under the impression that my tenure is extended.
There's a conspicuous difference between, suppose page 144 as you placed, or 145, take any one of those.
Yes, Your Lordship.
In those paragraphs, in those letters,
yes, sir.
Similar letter.
Yes, sir.
Please come to page 144 if you like.
Yes, sir.
In this context, it is requested similar, ABC are similar.
Yes.
So before that, the first paragraph categorically stated the contract was renewed for the period from such and such and further extended up to 16th February 2026.
Yes, sir.
Now, we don't find anything of that sort here. Oh, yes. No, the contract is not referred to. Is it referred to? Let us see 152. 152 is what you are relying on.
Yes, Your Lordship.
Sorry, 152, yes.
Yes, 152.
This is to mention that Sunshine such and such has resumed the existing 5 years contract with effect from such and such. So here,
That is not mentioned, Lordship.
contract period. So therefore, there is no admission on their part as to the contract
No,
period
but-
being extended.
But not there.
Only a
But by
travel
this traveling
allowance.
authority, the train is under me. I am providing the catering service till 19/6/2026,
Traveling authority
Lordship.
by per se does not mean anything. It may have been given to you to clear off your previous product. We don't know. I mean,
Lordship,
it's
then the
only
reason has to be, by what
contract.
forced them.
The difficulties regarding the contract we don't find because your pleadings also say it was last extended up
Yes,
to
Your
16.2
Lordship. Yes, Your
and then
Lordship.
you are vague.
Yes, Your
And you
Lordship.
annex documents regarding that
Yes, Your
up to
Lordship.
16.2.
Yes, Your Lordship.
Thereafter, there is no document, no specific date even given. In your pleadings in section 9,
Yes,
you
Your
don't
Lordship.
even give any date when it was extended. Please come to page 43. You are very specific up to para 12. There is non period from such and such to
Yes.
16.2 in respect of the said train.
Yes, Your Lordship.
Then 13 is one vague sentence. After the expired said period, the opposite party from time to
Extended
time
from
extended.
time to
Nothing.
time.
Nothing.
No
Nothing
document
to
is there,
substantiate,
Lordship.
vague statement, and you participated in a tender after that.
Yes, I have participated, Lordship. I have failed, but my contract was extended after that. From 28th, 20, February 2024, it expired
Even after, no, generally these
First-
tenders are floated previously.
previously, and it
And
was
the contract period
yes,
starts now.
and in 2026, I believe it was supposed to start.
So if you have participated in the contract and failed, then can you come up and get a similar
But
relief?
Lordship, Lordship kindly visualizes
You don't
that
find
train is-
anything to show that your contract was extended beyond 16th of February.
because Lordship, in my demand notice also I mentioned, which is on 12th June. Everything is before my section 9, Lordship.
Demand notice is not your cause of action. Period cause of action is that 5-5
5-5.
notice. That notice is not a notice to you at all. It's a general notification.
It is a general
So
notification.
how can that be a cause of action of your section 9 also? That is not a valid cause of action. Court passed the order on the premise of that notification
Yes,
only.
Your Lordship.
But that is no notice to you at all. It's a general notification. If it applies, applies. Doesn't apply, doesn't apply.
And Lordship, the force majeure clause also says that the tenure, in case of such situations, the tenure may be extended with the consent of both the parties.
Right, you're absolutely correct. But please come to para 12 of page 43. You have taken advantage of that already. And you admittedly say that extension of contract dies non period from such and such, which ended on 16th of February
16th of February.
2026. And para 12 is very specific. You are not vague on that.
Lordship,
Due to COVID pandemic, you got that advantage.
yes, Your
Force
Lordship.
majeure clause you
Yes, Your
invoked.
Lordship.
It ended on 16th of
16th
February.
February. So if we consider this, Lordship, I do not get the benefit under the notification. If we consider my submission, that is there on
The only
record.
thing we had to consider.
Yes, but Lordship, what circumstance forced the IRCTC to again
See, you
give
have
me
got a very
traveling
high
authority?
injunction. The very high injunction being this is public service. You want to perpetuate your contract, which would be rewriting the contract. This tantamount to
Lordship, if you-
rewriting the contract. Otherwise, therefore, you have to meet high standards to get such a sort of order in a public enterprise. It's
Lordship,
a public
if
utility
Lordship
service.
considers the other contracts which are to expire on or after 20th February, those are also rewriting because the force majeure clause says that the contracts which
Those
are not in force.
rewriting. Contract is an agreement consensus between the parties. Up to 16th of February 2026, there was a consensus between the parties. Contract is an agreement where
Yes,
both
Your
parties
Lordship.
agree.
Yes.
Up to 16 to 2026, it was
Both has
consensus
agreed.
ad idem.
Yes, Your
So
Lordship.
that was also a contract.
Yes, Your Lordship.
But this is not a contract. This what now has been directed, nobody else can participate. And after you fail in that tender, that would be rewriting your contract because there is no agreement between the parties.
No, this
The last
order,
agreement
this
ended on
impugned order, Lordship says that do not give effect to that.
Your pleadings, we are on your pleadings also.
Yes, yes.
Your pleadings give the last date to be 16/2/2026. Therefore, thereafter one big assertion that it was extended.
Extended from time to time.
What would you
Lordship.
do if you are the judge? You'll do the same thing.
Lordship, kindly one more trouble, Lordship. Page 127, it is
Yes.
that tender, Lordship. The clause is there, the force majeure clause.
That you have invoked, you have pleaded also. That's a
Lordship,
difficulty.
just the last line, Lordship. Further, if mutually agreed by both parties, the tenure of this agreement may be further extended for the period during which the license was not operational. So,
You
Lordship,
say that, you plead that, you
Yes.
rely on that. Para 12 is precisely what you are saying on that only.
Yes.
You say force majeure was due to pandemic, stopped, dies non, ended on 16th of February. Thereafter, one sentence, just to invoke jurisdiction.
My only point was the traveling authority, Lordship, since it was issued in my favor, even after much after my tenure has ended, Lordship, I am under the impression that it is extended. And Lordship,
There is no
practically,
substantive document to show you.
Is there any document, ma'am, in support of paragraph
Extended.
13?
paragraph, Lordship,
13 of the section 9 application at page 43.
the extension, time extended from Lordship.
If it was, it would be annexed here.
But if
annexed
Lordship
here.
gives me a day's time, I can take
No,
instruction.
no,
But
you have heard the matter. Yes, Mr. Bordon, how do you explain this traveling? This raises some presumption,
Milord,
doesn't
Milord,
it?
I read that over to you, Milord. I showed that. The reason behind, Milord, now kindly comes to page 375. I said there was an initial, Milord, earlier
So
miscase.
that is what you are saying, right?
Earlier miscase, there was an order, Milord. If I had not acted in terms of the order, Milord, I would have been hauled up for contempt. Kindly seize this order, Milord, page 375. It's 16/2/2026. And, Milord, the matter was made returnable on, Milord. It was made returnable sometime in the month of July. Imagine, Milord, order passed in the month of February being made returnable in the month of July. Addendum
78 is the ordering portion.
Yes, Milord. Milord, this order was dated 16th of February 2026, page 375. Milord, and kindly has a look at the order, Milord. 16th of February order, Milord, giving it force till, Milord, 2nd of July. But all that we have learned is injunction, 30 days extension, 30 days extension. Because every extension is an order under for the injunction. Otherwise, I would have been hauled up for contempt.
Yes, you are allowing the appeal. Sorry. Since arguable questions have been raised, we admit the appeal for being heard on the grounds taken in the memorandum. Full stop. As the ambit of the appeal is brief, we take up the appeal itself for hearing along with the application. Full stop. Next para, by the impugned order, a prayer for ad interim injunction sought by the respondent has been granted to the effect that the present appellant shall not stop the respondent herein to continue with service till July 20, 2026. Full stop. Next para. The order having been extended subsequently, the other miscellaneous appeal, bearing what is the other number of the other one? Bearing FMAT 266, no. FMAT 266 of 2026 has been preferred. Push up, both the appeals are taken up together. Push up, next para. The brief backdrop of the case is that the respondent turned out successful in a tender floated by the appellant, and pursuant to the same was granted contract for supply of cooked food in mobile train services. Push up, next para. The contract was granted initially for a period of 5 years and subsequently extended from time to time. Full stop. Next para. Due to the COVID pandemic which intervened, 2 years was granted as a dice non period, a period equivalent to which was now for a period equivalent to which the contract was extended, lastly till February 16, 2026. Full stop. Next para. Subsequently, by a notification issued by the Railway Ministry dated May 5, 2026, where is that? Which page number?
Page 148.
140.
The notification would be at page 150.
50. It was inter alia given out that certain instructions regarding force majeure clause were being issued thereby. Push up. Next para. The said office memorandum containing such directions, however, were applicable to contractual obligations which had to be completed on or after February 28, 2026. Full stop. Next para. The respondent took out an application under Section 9 of the Arbitration and Conciliation Act 1996, in connection with which the present impugned orders were passed, alleging that even subsequent to February 16, 2026, the contract was extended and was still in force. Full stop. In view of such prayer of the petitioner, the trial court, taking up the Section 9 application, passed the impugned order on the premise of the double inverted notice dated May 5, 2026. Full stop. Next para. Learned counsel appearing for the appellant submits that the said notification stroke office memorandum dated May 5, 2026 was a general notification and applied only to contracts which would have ended on February 28, 2026, whereas the contract of the respondent, even taking into account the dice non period, expired on February 16, 2026. Thus, the said notification was not attracted to the respondent's case at all. Secondly, it is argued that the respondent has suppressed that there was an earlier application under Section 9 of the 1996 Act filed by it, in which initially an ad interim order was passed, pursuant to which the respondent, the present appellant was constrained to keep the contractual relationship between the parties alive, although the contract had actually expired, by issuing traveling allowances to the respondent. Full stop. Next para. However, subsequently a challenge was preferred against the said ad interim order passed in the earlier round, which was ultimately held to be infructuous since the initial order obtained by the respondent therein was not extended further. Such facts, it is argued, were suppressed before the trial court. Next para. Learned counsel next argues that admittedly the respondent participated in a contract floated for tender of a tender floated for award of contract in respect of the self-same cooked food service, but turned out unsuccessful. having once participated in the contract and having failed to come out successful, comma, it is argued that the respondent, comma, in the garb of the present application under section 9 of the 1996 Act, comma, could not have sought a relief indirectly which it could not get directly by stalling the entire tender process. Full stop. Next para. Learned counsel appearing for the respondent submits, comma, by placing reliance on a communication between the additional general manager, comma, IRCTC and the chief commercial manager of the East Central Railway dated June 16, 2026, wherefrom it transpires that a request was made to the railway authorities to issue travelling authority to the onboard catering staff and supervisor of the catering licensee, that is the respondent, comma, as per commercial circular issued by Railway Board for the period from June 17, 2026 to June 19, 2026. Full stop. It is submitted that such request endorses the stand of the respondent that the contract was extended much beyond February 16, 2026 and, comma, as such, comma, the office memorandum dated May 5, 2026 was squarely applicable. Full stop. Next para, it is further submitted that although the respondent had participated in an earlier tender floated for the period after expiry of the respondent's contract, comma, the said fact per se does not preclude the respondent from claiming right under the dice non period which was given the benefit of which was given to the respondent in extending its contract. Full stop. Next para. From a perusal of the materials, comma, we find that in paragraph number 14 of the application under section 9 of the 1996 Act itself, comma, the respondent categorically admits that a fresh tender had been issued in respect of the self-same trains pertaining to which the respondent's contract relates, comma, during existence of the earlier contract of the respondent, which was opened on February 22, 2024. Full stop. Next para. It is also admitted that the respondent participated in the said tender. Full stop. Next para. Obviously, comma, the respondent could not have succeeded in the same since otherwise, comma, there would be no occasion for the respondent to seek a relief that the catering service to the concerned trains not be handed over to a third party. Full stop. Next para. After turning out unsuccessful, comma, having participated in the tender, comma, the respondent could not now turn back and seek to challenge a grant of contract in terms of the self-same tender in an indirect manner, comma, which could not be directly sought by the respondent. Full stop. Next para. Having participated and turned out unsuccessful, comma, the respondent is now stopped from challenging the tender and consequentially the grant of a contract in terms thereof to the successful tenderer. Full stop. Next para. Secondly, comma, we find from paragraph number 12 of the section 9 application that it is an admitted position that the 2 years dies non period for the COVID-19 pandemic was given to the petitioner and expired on February 16, 2026. Full stop. Next para. In the very next paragraph, that is paragraph number 13 of the application, comma, it has been stated by the petitioner, by the respondent, that after expiry of the said period, comma, the present appellant, comma, double inverted, from time to time extended the said contract and the said contract is still in force, double inverted close, full stop. However, comma, conspicuously, although the previous dates and contracts were categorically enumerated in the earlier paragraphs, comma, the averment of the contract having been extended after February 16, 2026 is absolutely vague and devoid of any particulars whatsoever, comma, even regarding the period for which the extension was granted. Full stop. Also, comma, we do not find any supporting document to substantiate such claim of further extension. Full stop. Next para, in this regard, comma, the respondent places reliance on a request by the appellant to the railway authorities to grant a travelling authority for 2 days between June 17 and June 19, 2026. Full stop. However, comma, we find evidence galore from the annexures to the Section 9 application itself that there were numerous earlier occasions when similar travel allowances were requested for. Full stop. In each of such previous requests, comma, we find specific mention of the contract having been renewed for the period from March 1, 2019 to February 28, 2024 and being further extended up to February 16, 2026 within bracket including the dice non-period bracket closed. Full stop. Next para. However, comma, importantly, comma, no such extension or expiry date of expiry of contract is mentioned in the traveling allowances relied on traveling allowance in the request for traveling allowance dated June 16, 2026 relied on by the respondent. Full stop. Thus, comma, such isolated document, comma, which is divorced from the general tenor of the of all the other documents produced by the respondent cannot per se create a right to plead further extension of the contract period. Full stop. From the other documents annexed to the Section 9 application, comma, it is evident that the contract, comma, including the extended dice non period, comma, lastly expired on February 16, 2026. Full stop. Hence, comma, in any event, comma, the office memorandum dated May 5, 2026, comma, which spoke about a period pertaining to February 28, 2026, comma, could not have 2026 as the last date of expiry of contract to come within the same, comma, could not have been attracted to the present case at all. Full stop. Next para. Even otherwise, comma, we find that the office memorandum dated May 5, 2026, comma, which was construed by the learned trial judge as a notice giving rise to the cause of action for the Section 9 application could not be read as such, comma, since the office memorandum was a general notification intended for all concerned and did not even apply to the contract of the respondent even prima facie. Full stop. Next para. Thus, comma, the very premise of the impugned order is bad in law and in fact. Full stop. Next para. In such view of the matter, comma, even without taking into consideration the earlier round of litigation as alleged by the appellant, comma, since those were not placed before the trial judge at the time of passing of the impugned order, comma, we come to the specific conclusion that the impugned order is perverse and is contrary to the the averments and materials placed before the learned trial judge. Full stop. Accordingly, FMA, sorry. What is the FMA number? FMAT. Parent order FMA is allowed on contest, comma, thereby setting aside the impugned order number 2 dated June 20, 2026, passed by the learned judge, 6th bench City Civil Court at Calcutta in miscellaneous case number 5890 of 2026. Full stop. Consequentially, comma, on FMATA is also allowed on contest, comma, thereby setting aside the impugned order নাম্বারটা দিয়ে দিও ওটা যেটা মেমোতে such and such. The connected applications bearing can 1 of 2026 also stand dismissed full stop in order to cause certain settlement.
Dismissed or disposed of? Can one?
Oh, sorry, dispose of.
My learned friend appears for the
Affidavit of
respondent one.
service filed to be kept on record. Was the other respondents?
Railway.
যেখানে যেখানে রেসপন্ডেন্ট অ্যাডভোকেট ফর দ্য রেসপন্ড কাউন্সিল ফর দ্য রেসপন্ডেন্ট বলছে রেসপন্ড নাম্বার 1 ওই শুধু পিটিশনে ছিল প্রথমে একটা লাইন উই আর অ্যাডিং আ লাইন এট দি টপ affidavit of service filed to be kept on record in view of the reliefs in the appeal having been sought primarily against the respondent of 1 comma service of notice on the other respondents is dispensed with.
I'm so grateful. So grateful.
You argued very well.
I'm so grateful.
Thank you.
Grateful.
Extension যদি দেখো 2024 এর দিকে
My appeal.
And for the respondent.
উনি কবে করতে গেছিলেন
তারপর দিয়ে করছিলাম যে তাছাড়া অন্য গ্রাউন্ড আছে একটু সেটি ছিল তারপরে yes Mr.
But this is a slightly different, what has happened is slightly different, so I'll approach it also a little differently.
Different from what, the previous matter?
No, different from most matters that I've moved. But Mr. Nayak had gone to City Court to move the matter. And that's why I have him here and specially briefed in this matter. Copy 27th of June. About 10 days before the order was passed, around that time, he went for the hearing. This was the plaintiff's here. A plaintiff had an ad interim order of injunction. 39-1-2 final hearing was coming up. We had a 39-4 pleadings were complete. He went and argued. The learned judge said that there's paucity of time. I'll not be able to hear you completely. Come back on the next day and finish it. On that understanding, he left. Then the impugned order was passed, where the 39-1-2 was allowed, and my application was rejected. Beyond this, it will be slightly embarrassing for me to say anything. I've actually lost a forum, and it's a very fact-heavy matter. My lord, the plaintiff, and I'm not really inviting your lordship to get into it also. I deserve that 1 or 2 hearings that were there. And if your lordship looks at the order, it to me appears to be some other matters order that has come in, because it refers to some ration shop, which is not the case here. It refers to me having admitted the tenancy of the.
That does not lack rationality.
Well, at least PDS, but this is not.
You are not on a ration shop.
I'm not nothing to do with ration shop. I have never admitted the tenancy of the plaintiff. It records I've admitted the tenancy. Halfway he left.
He does not run a ration shop here.
No.
Their case is that they're running a ration shop.
There is no ration shop. I'm glad she's here, because she would also know what has happened is.
No, obviously.
This is what, and I've lost one.
Both of them. I mean, we know that
I can't see the. Yes, of course. I couldn't see him. With her, it makes my life a little easier, but
I just
kindly set it aside if your lordship pleases to be.
And without going into the merits.
Yes, and
that
for the hearing,
the differences indicate
because
that
the ad interim order is still there.
This is what has happened, my lord. It's a fact-heavy matter. My learned friend is absolutely correct. There are previous suits, several proceedings going on. All has to be placed in details, my lord, if any conclusion has to be reached.
Because the ad interim anyways is there, so she will not.
I'm not opposing, my lord.
We are reviving it at the pendency of the 39-4 stage. Ad interim, whatever ad interim was granted to you, obviously.
Yes.
So it revives. We'll direct it to be to go back to that stage.
Please.
39-4 will be heard now.
39-4 along with 39-1-2. They were being heard together. So application can be heard after. Which is why I said it's a little different. No, it will just be set aside hearing. It will go back to 39 where it was, that hearing. পৃথিবী কোর্ট নেই সিটি কোর্টে দিয়েছে সামলাতে পারবো
the appeal is admitted and and is being taken up for hearing in view of the brief point involved. Full stop. Learned counsel appearing for the appellant submits that it will be evident from the impugned order that the same must have adverted to the facts of some different case, and there was a complete misunderstanding on the part of the learned trial judge. Full stop. It is submitted that on a date, this was a self-same date, 17th.
No, it was before.
On a date.
Oh, I'm sorry. Yes, it was
That
kept
date
on
itself,
that
yes.
date.
On the date of passing of the impugned order, comma, the matter was fixed for hearing of an application under Order 39, Rule 4 of the Code of Civil Procedure for vacating an ad interim order of injunction along with the injunction application itself. Full stop. The hearing was partly concluded, comma, under the impression that the hearing would be continued on the returnable date. Full stop. However, comma, subsequently the appellant discovered that the arguments had been concluded and both the applications had been disposed of by the impugned order. Full stop. Next para, learned counsel further points out that from the impugned order itself, comma, it will be clear that the running of a ration shop by the plaintiff has been referred to therein, comma, which is entirely divorced from the facts of the present case, comma, since it is nobody's case that a ration shop is being run therein. Full stop. Also, comma, we find that the order is cryptic insofar as reasoning is concerned. Full stop. Next para, learned counsel appearing for the
Respondent number 1.
Plaintiff stroke respondent numbers 1 and 2, comma, in her usual fairness and on instruction, comma, you are there also.
No, I was not
And
there.
on instruction submits concurs with the submission of the appellants to the extent that on the said date, comma, the hearing had not been concluded and that several factual facets are involved in the matter which were to be argued and to be adjudicated upon while disposing of the applications for injunction and vacating. Full stop. Next para. Thus, comma, it is palpably clear that the impugned order was passed on a mistaken notion, comma, upon confusing the facts with some other case. Full stop. Hence, comma, the same cannot be sustained. FMA 918 of 2026 is allowed on contest. Allowed, thereby setting aside the impugned order bearing order number 49 dated June 17, 2026, passed by the learned judge, 6th bench City Civil Court at Calcutta, in title suit number 980 of 2022, and remanding the matter to the learned trial judge with a direction to dispose of the application under Order 39, Rule 1 and 2, along with the application for vacating under Order 39, Rule 4 of the Code of Civil Procedure, upon giving adequate opportunity of hearing to both parties as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the trial court. Full stop. It is made clear that the ad interim order, comma, if any, which was subsisting on the said date in the trial court, is hereby revived, comma, subject, of course, to the outcome of the aforesaid two applications. This court has not entered into the merits of the matter, and the trial judge will be at liberty to decide all issues independently and in accordance with law. Can 1 of 2026 is also disposed of. No rest question. No. We are also thankful Mr. Banerjee is here. Yes.
Is my appeal, Millet?
Yes.
The suit was for the specific performance of an agreement for the sale of a land, Millet.
You are the plaintiff.
I'm the plaintiff, Millet. So I filed the suit and the ad interim order injunction was refused, Millet, in the application, Millet. I prepare an appeal this High Court, my lord, the Honorable High Court passed the order of identity of injunction till the disposal of the injunction application. Injunction application dismissed with the ground that I have the strong prima facie case, but the balance of inconvenience is in favor of the defendant, because number one, defendant is the owner, he cannot be injuncted. Number two, I prayed the alternative prayer in the plaint, section 21 of the Special Relief Act. This is the perversity. As per section 21 of the Special Relief Act, I prayed the alternative prayer in the plaint. So this is the balance of convenience in favor of the.
There is no caveat in the matter.
Yes, caveat is there. I served, my lord. Affidavit service is there, my lord. My lord's order is the previous order is at page, my lord, page 50 of my can 1, my lord.
That was the administrative stage.
Yes, my lord's order.
Not
then, my lord,
you don't want to be prejudiced by orders passed at the
yes, yes. But the factually totally incorrect, my lord. What the fact laid down in the.
Let us just check.
Yes.
Loan identity, so property belongs to the defendant.
That is from on perusal of the document and the merits on record. It starts from.
You have got a registered agreement.
No, but unregistered agreement is admitted, my lord. The main is the terms of the condition of the agreement.
What was the defense in the written objection?
There is no defense that we have failed to. Because the time is the essence of the contract. We have failed to pay, but it was not my obligation, my lord. The last order, my lord, has been set down. What was the obligation of there? Because the terms of the contract has been ignored, my lord.
What is the injunction you asked for?
Well, the previous my lord's order was restored.
So what injunction?
My lord, kindly come at page can 1, my lord, at page 50. Lord, it start from paragraph 50, page 54. What is the clause of the contract, my lord? That has not been considered. This was the basis. I offered to pay the balance consideration. I said the deed of conveyance. He refused. Paragraph 50 is the basis of the case. Court will fail to consider these things. That has been totally failed to consider. Actually, totally incorrect. Totally perverse. So the point of fact, the law. So my humble submission will kindly pass the order of injunction till the disposal of this can 1.
The present appeal has been preferred by the plaintiff in a suit for specific performance of contract, whereby the temporary injunction application of the plaintiff stroke appellant has been dismissed on contest. Position of learned counsel for the appellant points out that the learned trial judge proceeded on the erroneous premise that the plaintiff has also sought for a relief of damages to refuse injunction, by overlooking the legal effect of an alternative relief of recovery of damages comma, which does not in any manner, comma, vitiate the principal relief of specific performance of contract. Secondly, comma, the learned trial judge observed that since the property belongs to the defendant stroke respondent, comma, if an order of injunction is passed at this juncture, comma, the defendant has more to lose than the plaintiff, and the balance of convenience and inconvenience is not in favor of the plaintiff. It is argued that the said premise is also erroneous, comma, since in a suit for specific performance of an agreement for sale, comma, it is obvious that the title of the defendant is admitted, and it is only for that reason that an injunction is sought. Next para, that apart, comma, it is rightly contended by the learned advocate for the appellant that the learned trial judge failed to advert to the materials and pleadings on record, comma, inter alia indicating that in terms of the clauses of the agreement, comma, the appellant has already made the initial payment of earnest money at the time of entering into the agreement, and the balance consideration was payable only on the date of final registration of the deed. Next para, thus, comma, a strong prima facie case for grant of injunction was apparently made out, and the appeal is required to be heard on the above questions and the other grounds taken in the memorandum of appeal. The appeal is accordingly admitted. Next para, the respondent one, respondent and her men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, encumbering, and or parting with possession of the suit property in favor of any third party in any manner till disposal of Can 1 of 2026. The appellant shall serve a copy of Can 1 of 2026 as well as a copy of the memorandum of the appeal on the respondent, indicating that the application shall next be listed for hearing in the monthly list of October 2026, when an affidavit of service to that effect shall be filed by the appellant. Affidavit of service by
He has already filed. There was a caveat was there.
Sorry. প্রথমে লিখে রাখতে affidavit of service filed to be kept on record, despite service none appears for the caveator opposite party, ওটা শেষ হয়ে গেল। আর লাস্টে একটা লিখে দাও, affidavits if any shall be exchanged in the meantime. We are keeping the application alive.
The plaintiff in a suit under section 106 of the Transfer of Property Act, respondent in the first appeal is the appellant before your lordship. If your lordship takes up, because the issue with regard to service, first miscellaneous appeal since against the order of remand by the first appellate court, with regard to the issue of service of notice under section 106. May I take your lordship, to the trial court judgment, the last certified copy before your lordship. My lord kindly takes up page 4, because my assertion is that twice it was served, AD card returned with the
dismiss the suit or decreed
the suit. Lord kindly takes up the specific issue number 3 that has been framed.
Yes.
Is the notice under section 106 of the Transfer of Property Act is correct, legal, valid, sufficient, and binding upon the defendant according to law. Kindly takes up what is the observation of issue number 3.
Exhibit 4 series, 5 series, all these are there.
Yes, all are there. Kindly takes up page 6, internal page 6, how the issue number 3 is being dealt with. May I place issue number 3, second paragraph, the written statement. The written statement filed by the defendant appears that the defendant has denied that the plaintiff sent a notice to him, and it is also denied that any such notice was ever served upon the defendant. To this fact, plaintiff produced the advocate's letter along with the AD card and which are marked Exhibit 4, 4A, 4B, and 5, 5A, and 5C series. In the present case on perusal, I find that the notice was prepared by the learned advocate such and such, and the same is dated 27th of April 2007, sent on to the plaintiff upon the defendant. On perusal of the said notice, I find that the schedule of the suit property as mentioned in the letter is the same as mentioned in the plaint. It appears from the notice that all the grounds for which the plaintiff has filed the present suit has been mentioned in the said notice, and a reasonable period has been given to the defendant to vacate the suit property. The address which has been mentioned in the notice is the same as one being mentioned in the cause title of the plaintiff of the original plaint, upon which the defendant received the summons received through this court. The copy of the eviction notice and postal receipts, Exhibit 4, 4A, 4B in series, 2 envelopes containing eviction notice with ID card.
You have read up to the next page.
So,
how was it reversed?
Kindly takes up now, Milord, the appellate court. Only the relevant portion, Milord, I shall. Kindly takes up page 27, internal page 27 of the appellate code.
Yes.
Milord, nearing the middle, Milord, it starts, I find that. Milord, got it? I find that the learned trial court had not specifically framed any issue with regard to the service of notice upon the defendant, with regard to service of notice upon the defendant, but has touched upon the same, observing that there is a presumption under section 27 of the General Clauses Act. Though not necessary, still it appears that no issue were framed with regard to the title of the plaintiff, but the same was discussed by the learned trial court. The learned trial court failed to frame a vital issue with regard to the service of notice upon the defendant, and I find that the evidence was not laid on this issue.
This is also probably a ration shop case. You were there?
No. Yes, I was there.
Ration shop was referred to. There
Yes,
is no
yes.
ration shop run by either of the parties.
I had. Milord,
Same look, na?
and the operating part, your lordship, kindly see at page 30
Yes.
and 31.
Clear the doctrine of ration shop.
30, Milord, last two paragraphs, and 31 in its entirety. Milord, learned judge, Milord, swayed away with regard to the fact that whether, Milord, merely saying no will not do. Now this honorable court has made clear. Once a notice is being served, positive assertion, merely saying no will not do. Once the ID card, postal receipts, all are there, there is a presumption. He has to come out, Milord, from no to such an extent that something is rebuttable. Mere saying is not a rebuttal. Now, Milord, our Milord, honorable court has made that clear, relying upon the honorable Supreme Court judgment. Because honorable Supreme Court has went up to that stage that if mere saying is no will rebuttal, then the postal authorities, every Milord, Milord public servant should come. Yes, yes, that's the position.
You directed to serve a copy.
Yes, yes, Milord, I only, Milord, pray for that, because on this issue, Milord, kindly dispose it off on the next day. I shall, Milord, serve and come back before your lordship.
Only the plain. No. Why are 2 to 6 pro forma respondents?
What a pro forma?
Is it a contest or what?
Plain.
Take up.
May I just?
They have not filed, but they have not filed the appeal.
They are also defendants.
They were defendants, but they have not filed the appeal.
Oh.
Defendants, but they have not filed it.
But সেখানে cost title কোথায় আছে?
Decreed against all on contest.
Oh, Milord, the one of the defendant only, Milord, preferred the appeal, making, Milord, others as pro forma.
But still all have to serve.
Yes, I will serve all. Yes, yes, Milord, I will serve all.
Learned counsel for the appellate argues that the learned first appellate judge erred in law in remanding the matter to the trial court, despite the trial court having passed a decree for eviction on the ground of section 106 of the Transfer Property Act 1882 by categorically framing relevant issue as to whether the notice under section 106 was correct, legal, valid, sufficient and binding upon the defendant according to law, and also extensively dealing with the evidence and coming to a conclusion that notice was duly served on the defendant stroke respondents. Push up the learned first appellate court comma, it is pointed out, comma, tangentially approach the matter by observing that the learned trial judge had not specifically framed an issue with regard to service of the notice, but has touched upon the same by applying a presumption under section 27 of the General Clauses Act. Full stop. Next para. It prima facie transpires that although the notice, comma, literally, comma, was restricted to whether there was a valid and sufficient notice, comma, the sufficiency of such notice includes within its ambit the valid service of the notice as well. First of, it is further evident from the judgment of the learned trial court that both parties addressed all issues, comma, including service elaborately, and those were discussed at length by adverting to all the evidence on record by the trial court, comma, thereby obviating the observation that no specific issue was framed on service. Full stop. Next para. Thus, comma, a very arguable ground of hearing the appeal on merits has been made out, inasmuch as whether the learned first appellate judge erred in law in remanding the matter by overlooking, remanded the matter despite the learned trial judge having learned trial judge being justified in coming to the conclusion that notice under section 106 of the Transfer Property Act was duly served and granting an eviction decree on such ground, and also by overlooking order 21 rule, order 41 rule 24 of the Code of Civil Procedure. Full stop. Hence, the appeal will be heard on the above questions and the other grounds taken in the memorandum of appeal. The appellant shall serve copies of Can 1 of 2026 as well as a copy of the memorandum of the appeal and a server copy of this order and server copies of this order on the respondents, indicating that the application shall next be listed for hearing in the monthly list of September 2026, when an affidavit of service to that effect shall be filed. Full stop. Next para. It is made clear that in the event due service is effected on the respondents, comma, the appeal may be taken up for hearing along with the application on the returnable date. Any other document is necessary?
No, my lord, nothing.
No, but
if your lordship desires, my lord, I shall place, my lord, only with regard to issue number 3, the postal receipts and all those, my lord, evidences which was placed.
Statement formally should be brought on record.
Very well, my lord, your lordship can call.
We'll direct you to file. We are keeping it in the monthly list of October. October kore daw.
Very well. I shall prepare
as an application. In the meantime, comma, the appellants shall prepare and file the requisite number of informal paper books without comparing with the records. Full stop. The notice indicated above shall be construed to be the notice of the hearing of the appeal as well.
Let the stay of all further proceedings.
Oh, yes, there shall be stay of all further proceedings in title suit number
93 of 2007.
93 of 2007, pending after remand before the learned civil judge, Junior Division, First Court at Bosirhat, District North 24 Parganas, till disposal of Can 1 of 2026.
I'm grateful.
Lordship, I am for the respondent in this matter led by Mr. Bhattacharya, senior learned.
Mr.
Nilanjan Bhattacharya, senior standing counsel. Lordship, due to his personal difficulty, he is not available to the kindly.
Not come to court.
Lordship, he is in virtual mode, but due to her illness, he is unavailable at this moment, Lordship. That's why not pray for not today, Lordship.
No, on the last occasion also granted return.
Lordship, this is new brief I got.
Yes, what do you say, Mr. Pahadi? Ask for time.
I cannot object your lordship, kindly take it to matter in anything. Next.
Mr. Bhattacharya cannot appear online also.
Lordship, he is on.
Use the microphone, you can't hear it.
Lordship, actually, his health is not good, Lordship.
Acha, very good. An adjournment is sought on the ground of ill health of learned senior standing counsel appearing for the state. So accordingly, let the matter stand adjourned for the day. But on the next occasion, please come prepared.
Lordship.
If he is not there, you come prepared.
Lordship.
Mr. Pahari has been coming on the last occasion also. He came. Yes.
This date.
Well, very short fan. Just review application.
You are appearing cannot be very short. Yes.
Number 13, I'm from petition, my lord.
Right.
This is my application.
Yes. You are for the same.
Press ability,
Private. We thought all the good counsels were. Yes, what is the matter?
My lord, the petitioner filed this present application, my lord, challenging the order dated 26 September 2025 in original application on 979 of 2023 passed by the my lord Honorable West Bengal Tenancy Tribunal, my lord. My lord, the petitioner filed an application before additional rent controller Baraku to deposit certain amount of rent, same was allowed. And petitioner subsequently deposit the amount. Challenging the order, my lord, the respondent of 5 challenged the order before the Honorable Tribunal, alleging that the application was suffers from non-joiner necessary parties and is not in consonance with the provisions of section 21 and 22. Same, my lord, same application, my lord, filed in order dated 26 September 2020.
You are Mr. Shatra?
No, my lord.
What's your name?
Mr. Onit De.
Mr. De. Mr. De will continue after the recess? Oh, right.
That is the also problem.
Come.
Also, my lord.
Yes.
Oh, a resolution has been taken?
Yes, my lord. And timely
We'll
date of-
formally sit. If nobody comes, then we will not take up. Anyway, so then very well. Although the hearing is commenced, the matter cannot be disposed of today due to paucity of time. So accordingly, let the matter be adjourned for the day.
Monday is for some difficulty.
Monday difficulty. Very well. Adjourn till adjourn for the day na kore, adjourn till August 18, 2026.
Great.
Today we kept on record.
No.
May I have to mention on contempt application?
This
But-
bench?
Yes, my
Yes, yes.
grateful.
কত নম্বরে? হ্যাঁ, টু বি মেনশনটা ডেকে নিন। টু বি মেনশনটা 1 মিনিট লাগবে।
প্রচুর ম্যাটার আছে।
টু মেনশন কেন যাবে না? Mr. Chaudhary, you are appearing in one.
Yes, my lord, I appear for the review applicant, but my lord, because of the resolution, since nobody is there, my lord, if lordship will let it retain its position, that's all.
Yes, yes, it will. So why was it appearing as 2?
My lord, I understand lordship had indicated that the point is short, lordship would hear it in to be mentioned itself. I am ready, but because of this, my lord, I don't want to.
You are for the review applicant?
For the applicant, yes. Very short point, my lord. Two Supreme Court decisions, my lord. We want to bring it to the notice of the bench, and after that, lordship will consider under Order 21, Rule 99, and one under, my lord, Section 213. That's the short point.
Although the review applicant is represented through counsel, none appears for the opposite party in the review application at the time of call. Full stop. Accordingly, let the matter stand adjourned for the day. It will appear under the heading 2 mentioned.
Very well, very well.
Supreme Court change করে দিয়েছে। একই হবে জানি না। Yes, sir.
Kindly see, my lord, the order dated 10th July 2026. Paragraph 8.
Appearing?
Yes, ma'am.
Why didn't he appear on the last occasion?
Last one is.
And due to some reason, personal reason, he could not appear. He told me that there is a direction given by this honorable court today. That is why I have to appear. He has appeared, my lord.
Yes, what do you say to this? You have seen the order?
Yes, I have seen, my lord. It's my duty. I have to comply because rightly the court has passed the order. I am filing my unconditional apology, my lord, because on the last occasion also, my lord, I have paid the litigation cost also.
What about the alimony?
And litigation cost I have paid. I beg your pardon, my lord.
Not also.
Litigation cost, my lord, I have paid.
Yes.
There is some due, my lord, due to my financial crisis, my lord. I could not make the payment, but well, I will pay. Well, I will not saying that I am not saying that I will not pay. I have to pay, my lord. Now, kindly, if my lord will grant me some more time.
No, but there were certain incorrect averments in paragraph 22 of the opposition.
Yes, my lord.
We had recorded that there were certain incorrect averments in paragraph 22.
Yes, my lord, I have clarified, my
You
lord.
had alleged that you had complied.
Yes.
What
But
about that?
if my lord will kindly come to the paragraph number 2 of my affidavit, my lord.
22?
Yes, my paragraph 2
of this.
Yes, of my unconditional.
Copy that.
Yes, copy. Sorry. That in my affidavit, may I read, my lord?
Yes.
That in my affidavit in reply at paragraph number 22, which specifically mentioned in order dated 10th July 26, and I have misleaded the honorable court in making incorrect averment for compliance of the order dated 1st April 25. But at the said paragraph number 22, I have specifically stated that in compliance of the order dated 1st April 25, I am paying rupees 40,000 each month to the respondent wife, and I am paying the son each month above rupees 20,000 separately, and I have also paid the litigation cost of rupees 60,000 in compliance with the order dated 1st April 25. And at the last part of the said paragraph, I have stated that I could not pay the area maintenance till March 25 from the date of filing of the alimony application. And what I have stated in the said affidavit in opposition is correct, and I never have any authority to mislead the honorable court, and I am bound to comply.
What was the direction? What was the direction to pay?
60,000.
Total lump sum 60,000.
No. Per month,
60,000.
along with date from the date of filing of the application, arrears are also
Yes,
due.
no, it's
Yeah,
60,000.
so lump sum 60,000 for son as well as whatever.
Yes.
So, but then you said it is in compliance with the order,
Yes.
but the
40,000 I am paying time to time.
40,000 is was not the order. Order was 60,000
Absolutely, my lord.
composite.
It's absolutely, my
So you
lord.
said you are paying in compliance, but it's
Yeah, that is why, my lord, I have filed
separate
this.
payment to son.
Yes.
Now, what is the proof of that?
The problem is that well, I have only
That
paid.
is where you misled the court. That is
Yes,
what we held.
Yes. My lord, in the affidavit, my lord, if my lord will kindly, may I read, my lord, the entire paragraph number TS, my lord. And at the last part of the said paragraph, I stated that I could not pay the area maintenance till March 25 from the date of filing the alimony application. And what I have stated in the said affidavit in opposition is correct. And I never have any authority to mislead the honorable court, and I am bound to comply the order.
That we also know you are bound.
Yes.
But where is the proof that you have paid to your son separately?
In respect to the son, I did not pay. I have to pay, but my lord, due to
No,
my
but you had
financial,
stated that.
but I have paid the litigation cost.
No, you had stated in that paragraph that I have
also
specifically
paid the
stated-
litigation cost of rupees 60,000.
No, you had stated you admit here, para 2, but at the same paragraph 22, at the same paragraph 22, I have specifically stated that in compliance of the order such and such, I am paying 40,000 to the respondent wife, and I am paying the son each month above.
I have stated
rupees 20,000.
I totally agree.
That is a
with-
wrong statement.
Wrong statement in the affidavit in the main application I have stated, but when I made the affidavit in apology, but the statement has not been correctly drafted. Right now, they told me that that is the difficulty.
You have not stated anywhere. It's not correct.
Yeah, that has not been stated.
Then
my only prayer, I have to comply.
So why shouldn't you be hauled up for contempt? You misled the court. Absolutely. You said you paid separate 20,000 to the son. You have never paid any such amount.
That is why, my lord, I have filed this affidavit. But
that affidavit is just lip service. Because you are hauled up for contempt, you are at the threat of going to jail. You are doing this.
My
This is not an apology. You had misled the court. You had made a wrong step. Why shouldn't you draw up a proceeding under the appropriate provision of the PNSS?
It's my fault.
Corresponding to 340 of the earlier.
May I pray only
You never paid 20,000. You stated
I have paid 40,000 and the
You
litigation.
stated in your opposition you are paying separately 20,000 to the son. But what prompted you to write this then?
That is why, my lord, I have filed this affidavit. But
This affidavit will throw away in the basket. Why should you take this affidavit at all?
But whatever I've
You
stated,
tell
my
that
lord-
you have the audacity to tell the court that you are paying 20,000 separately to the son.
Yes.
You are paying not a single farthing to the son.
But my lord,
For this alone, you should go to jail. And this is a separate act of contempt, which is why you had its aggravated contempt.
Yes, in respect to the some month, as far as the advocate on record told me that they have paid some month, April
Where is
month.
the proof? You have not annexed anything. Here also you have not annexed anything.
देखिए दीजिए proof.
After our order, 20,000 to the son.
Main affidavit টা ওদের
And we did not direct you to pay any separate amount. You have to pay everything to the wife.
I have to pay.
You will take for the son.
I have to pay. It's my duty. I never.
So are you ready with the money now? The entire arrears.
But I have stated in my affidavit because of my some financial crisis, I will pay. If my lord will kindly grant me some more time, if I will not pay, my lord,
What more time? Tell us.
At least 2 months, my lord.
No question of that. We'll give you a week at best.
At 20 days at least, my lord, if my lord will kindly.
Yes, Mr. Bhattacharya, what do you say?
Milord, two things, Milord. On the threat of contempt, Milord, today morning, Milord, my client has received an SMS from the bank. Milord, at least, Milord, my lord had directed 50,000, Milord, as litigation cost. I take it 50,000. He has discharged only that part. Today morning, my client has received in his account that 50,000 today. As of today, Milord, kindly comes to Milord R1, Milord, 50.
What is the direction for litigation costs?
Yes, Milord, it was there.
Directed to be paid.
Yes, Milord.
Yes, 50,000. Yes.
Paragraph 12.
What was the amount directed?
Milord, 60,000 per month and 50. Paragraph 12 of your lordship's order under contempt. Milord, that is. Milord, order dated, Milord, 1st of April 2025.
Yes, 50,000. That he has paid this morning.
Today morning.
No, my lord, 12th, subject to correction to my learned senior friend, my lord, 12th August 26. 12th August 26, that is today, like we have paid. Now we will pay.
Yesterday.
Yes,
Day
yes,
before yesterday.
Yes.
But it, Milord, we have received an intimation, SMS came
Live
to us,
statement.
Milord.
Live statement that
You have to pay to her. Your bank has intimidated.
No, clients, Milord, the wives. Yes.
Bank has
Yes.
intimidated you.
Milord,
So may have been paid on 12th. Whatever, that doesn't make a difference. This is
one. And Milord, another, Milord, kindly see, Milord, they have themselves given a statement, Milord, at page 15 of volume 1 of their affidavit in opposition. This was all, Milord, kindly see, Milord, in the paragraph they said, Milord, they have given the minor son, Milord, separately, Milord. This is their own statement, every month 40,000.
You are you are misleading the court, absolutely. Your conduct is deplorable. You give a lie to the court that you are paying 20,000 to the son separately, a minor son. How dare you do that?
I beg your pardon.
No, sorry, no. We'll send him to jail right now from here.
But if my lord will
How
kindly,
dare you tell the court that you are paying 20,000 separately to the minor son? It's an utter lie.
that is why, my lord, we have made the affidavit in apology, my lord.
We are throwing this in the waste paper basket. Affidavit of apology. Who cares for your apology? This is not an apology. Pay the wife immediately.
I will pay.
You are directed to pay her 60,000 lump sum, 50,000 litigation costs, 50,000 you have paid only yesterday, day before yesterday, after getting a rule of contempt. You do not appear before the court. And you write in the affidavit in opposition, affirmed on oath, that you have paid 20,000 separately to a minor son. What is the age of the son?
Class 8.
Class 8 son, you are paying separately 20,000. It's an utter lie. Why shouldn't you send to jail right now from here? And it's a separate act of contempt. You'll suffer imprisonment for a week for this only. And regarding the other contempt, we'll keep the matter pending.
May I pray only one thing, my lord? I know, my lord, it's our fault, my lord. It's our fault. I will not say that whatever in the affidavit it has been stated.
It's a very easy ploy. It has been deprecated
I
by the
totally
Supreme
agree.
Court time and again, by us time and again.
Agree with you,
That
my
when you are at the threat of contempt, you are just standing coolly and filing an affidavit of unconditional apology.
I totally.
What sort of unconditional apology is this? How do you write before the court that you are paying 20,000 separately? Why do you write it? What is the reason? Yes? Why shouldn't you put you to jail right now?
If my lord will kindly give me 20 days time, if I will not.
Will not give you 20 days time, definitely. Why should you give you 20 days time? When was the order passed?
1st April 2026. 2025.
The wife and the minor son are spending their days hand to mouth with direct long back. Why should you give you one further day? Sorry, no. 1st of April 2025. More than a year has elapsed. Not a single more day.
No. If my lord will.
No, we don't accept your apology.
Yes, my lord. If my lord will
And
kindly.
we'll immediately commit you to prison. And we'll dispose of the contempt. We'll make the
If
route
my lord will
absolute.
kindly.
No, he'll be spent behind the bars for a month. And for this only. And otherwise, we'll leave it open to them to put that order to execution, like in an original said decree.
May I only pray one thing, my lord?
No,
If my
nothing.
lord- due to my financial crisis, I have stated.
Whatever.
I have to pay. I'm not saying that it's
Your
my duty.
contempt does not lie only in your
I
non-payment.
totally agree. With respect
You
to
boldly
the wrong
file an
statement.
affidavit in court. You say you have been paying separately 20,000 to the son.
That is.
He'll be taken to custody immediately. No.
If my lord will, my lord, kindly, I have to pay, my lord. If in between the 20
It's
days,
your
my lord,
choice. You have not paid for a
I
year.
will pay.
For a year.
Well,
You have to file a contempt application here.
That is why, my lord, I have stated in the affidavit that due to my financial crisis, there are certain loan. That is why I could not. I will pay. Like if 20 days.
40,000 you have been continuously paying.
Yes, 40,000 I am paying. Well, I will pay. Well, if kindly give me at least time. If I will not pay, well, even I am telling, my lord, that I will not pay.
No, but what about this misstatement in the affidavit? How can you condone that? It will set a very bad example.
In respect to this statement, my lord, when the advocate on record, my lord, told me that in respect of this statement, I told him that this is not a correct way. That is why, my lord, we have made this affidavit. I know, my lord, this affidavit will not
If you
suffice.
knew it was not the correct way, why did you write it?
No, I did not. My lord, the advocate on record has prepared the same. That is why, my lord.
Then let us issue a rule of contempt against the advocate on record also. If they take responsibility.
No, my lord, it's our fault, my lord. We will not kindly give it.
If it's the advocates on record's idea, then they should go to jail also.
No, my lord, that is why, because of the wrong statement, he has filed this affidavit for the apology because of the wrong statement, my lord.
What is the reason for making the wrong statement? What is the explanation? You got called out and then you file an affidavit of this apology. We don't accept it. Sorry.
If I have paying 40,000 time to time, if my lord will kindly grant me 20 days time, kindly, my lord. If I will not pay
the misstatement in the affidavit in opposition, we'll immediately send you to jail. You pay whatever means you have to pay.
I'm kindly, my lord, grant me, my lord. I will. I beg
Why
your pardon.
Why should he condone the misstatement before the court?
I know, my lord, it's a misstatement. I will not say, my lord, this is a misstatement. Misstatement is misstatement.
No, everywhere
Well,
condonation sometimes is
Right.
seen as a sign of
I'm
weakness.
not.
No,
May
seen
I
as a
pray-
sign of weakness. No,
May I pray only one thing, my lord?
we don't have any personal stake in it as
I
judges.
know, my lord.
You don't have any personal stake here.
Absolutely, my lord.
It's a question whether the dignity of the court is undermined by flouting its order first, and then for 1 year you don't make the payment, and then you come up and have the gumption of filing an affidavit in opposition saying that no, I have paid
Absolutely.
20,000 separately to the son. We are sending you to jail immediately for that.
May I pray only one thing, my lord? Lord, in the 20 days, my lord, I will pay.
পুলিশ হলে তাহলে হবে কি আছে পুলিশ
40,000 I am paying time, I will pay. Kindly,
বিজনেস লিখছে যে বিজনেস what is your business?
Lord, that is the purpose of Milord 5. That is why this order was passed, because kindly see, Lord, that Milord order of alimony, Lordship there specifically Milord had held that Lordship directed the in terms of judgment of Rajneesh versus Neha, affidavit of assets have been filed. They filed. Milord, no Milord ITR filed, no bank statements given. Lordship, that's why make a specific Milord observation. This is gross suppression. One. Number two, that affidavit was Milord accepted by your Lordship subject to payment of cost of rupees 10,000. Since Milord they have thrice Milord took extension of time Milord for filing that affidavit. This is two. And now Milord, since Milord this is and earlier Milord another cost of 50,000 was imposed by a coordinate bench presided over by Justice Harish Tandon.
Similar reasons.
That was Milord. What happened, Milord? Since where the wife and the son is staying in a flat, Milord, allegedly owned by the Milord husband, Milord, there was Milord non-payment of maintenance charges of the society as well as Milord the electricity charges. The CESC issued disconnection notice. We immediately mentioned it before Justice Tandon's bench. Then Milord 50,000 ad hoc was directed to be paid.
Those are direction on them to pay, meet the electricity charges or what?
As an ad hoc for immediate relief before Puja vacation. My lord also Milord imposed 10,000 cost for 3 thrice extension of time Milord for filing and 26th March 2025.
The title return was filed.
No, it was. That's why my lord's observation, kindly see gross suppression.
Yes. Para 9 onwards.
Para 9 onwards.
This false statement of 20,000 was made in the affidavit in opposition to the contempt application.
Contempt application. And Milord, kindly see Milord, page 15, Milord. এটা কোথায় draft এটা volume 1
volume 1
15 of what?
Page 15 R1 of volume 1 of opposition affidavit in opposition. Volume 1
yes, page 15.
Kindly see, this is their own Milord step. Every month 40,000 every month.
The date of filing of the application is after passing of the order.
And that too, Milord, kindly see your Lordship's order from the date of filing of the application. They have started giving from 12th April from the date of the order.
Arrears have not.
No, as of today, arrears is 1242,850. Oh, till April. This is till April.
No, we'll send it to jail.
Right. May I only pray one thing, my lord will kind.
Even if you send him to jail, you have to pay the subsistence allowance. Yes.
Right. If my lord will come, I will try to clear. Even my lord, the client is here. He told me that he will try to clear all the dues within the short period of time.
What short period? How do you purge that contempt? By misleading the court?
It's the wrong statement.
How can you have confidence on you? You have been recalcitrant on 5 occasions at least previously. 3 occasions you did not file an affidavit of asset. Lastly, you suppressed. Justice Tandon, before Justice Tandon, similar situation, 50,000 cost. We awarded 10,000 cost. You have not paid the arrears till date. Arrears were to be paid, you are late by a year.
But we have paid the litigation cost, but area
Yes,
we have
before yesterday.
12th August.
So today we are on 14th August.
My lord will kindly grant me a time. We will try to clear all the dues. But kindly, my lord, as last chance, my lord. It's my submission. If we will not pay, court will, my lord. Kindly make it as last chance, my lord.
No.
I will pay, my lord.
No further chance.
Kindly, my lord.
You have lost
For
confidence.
20 days, my lord. Not more than
You have
that.
lost
If I will not
confidence on
clear,
you, sir. No.
my lord, I will clear because, my lord, if my lord, my family is also, I will pay, my lord. If my lord will kindly, my lord, grant me at least 20 days. Time,
No, sorry.
Kindly, my lord. Kindly.
At the time of no, the contemner personally appears in court along with counsel. Which of next para, we note from our earlier order dated July 10, 2026, that apart from having squarely violated the order dated April 1, 2025, whereby the contemner was directed to pay a monthly alimony amount of rupees 60,000 as a composite amount for maintenance of his wife and son, the contemner did not also pay litigation costs till day before yesterday, as well as flouted the direction to pay arrears of alimony for more than a year. For sub next para, not stopping there, as we had recorded in our order dated July 10, 2026, the contemner had the audacity to make a patently false statement in his affidavit in opposition to the contempt application, alleging that although he had been paying only rupees 40,000 each month to the petitioner wife, the contemner had been allegedly paying rupees 20,000 separately to his minor son. First up, son is 8 years old.
Class 9,
Class
14.
First up, next para. During arguments, an affidavit of double inverted unconditional affidavit for unconditional, double inverted affidavit for unconditional double inverted clause is filed on behalf of the contemner. First up, learned counsel appearing for the contemner submits that the contemner tenders unqualified apology for having violated the order of the court and submits that the contemner is willing to clear off the entire dues of the petitioner within an outer limit of 20 days from date. First up, next para. However, even from the affidavit which is filed today and kept on record, we do not find a single line of plausible explanation having been given as to why the contemner made the patently incorrect statement in his affidavit in opposition to the contempt application to the effect that he was paying rupees 20,000 per month separately to the minor son. Full stop. Apart from the separate payment to the minor son, who is only about 14 years old, and is in custody of the petitioner mother, being absurd and not credible, not a single scrap of paper has been furnished to substantiate such claim. Full stop. Rather, when confronted with the said issue today, the contemner admits through counsel that the said statement was incorrect and he has not made any such payment to his son. Full stop. Thus, not only did the contemner not comply with the order of this court for over a year from the date of the order, but also tried to deliberately mislead the court into believing that he had been complying with the order. Full stop. Next para. In the teeth of the contempt, comma, the contemner has paid the litigation costs only, that too day before yesterday, that is on August 12, 2026, comma, evidently to save the rigors of contempt. Full stop. Next para. We also take note of the fact that previously, comma, during the hearing of the alimony application, comma, costs had to be imposed on the contemner in view of the contemner having repeatedly sought adjournment to file his affidavit of assets. Full stop. Even in the affidavit of assets, comma, as we noted in the order under contempt, comma, several components were suppressed by the contemner, comma, trying to cover up his actual income before the court. Full stop. Next para. That apart, comma, on a still earlier occasion, comma, that was a coordinate bench. Or
Yes,
single,
yes.
a different coordinate bench had also to impose costs on the contemner for having flouted a previous direction of payment of an ad hoc amount to the petitioner wife. Full stop. Next para. Taking into consideration such repeated and deliberate acts of contempt on the part of the contemner, and that the contemner does not care in the least for the dignity of the court in having made a deliberately false statement of having paid rupees 20,000 per month separately to his minor son, comma, which is admittedly an incorrect statement, comma, we find the so-called apology sought to be offered by the affidavit filed today to be only an eyewash and a lip service, comma, not worth the paper it is printed on. Full stop. Next para. Hence, comma, we categorically refuse to accept such purported apology, comma, which in the garb of an apology, comma, is a lame excuse to avoid the punishment for contempt. Full stop. Next para. If such recalcitrant litigants are let free without any penal action for such aggravated contempt, comma, a wrong message will go to law-abiding citizens, comma, since such abidance by the law would lose meaning if people are permitted to flout the directions of the court at the drop of a hat and to merely tender an apology and uh, be let go scot-free. Full stop. Next para. Hence, comma, taking into account such repeated and aggravated acts of contempt on the part of the contemner, comma, the rule bearing CRC 14 of 2026 is made absolute by directing the contemner to be taken into custody. First of the contemner shall be committed to civil imprisonment for the period of a week starting from today. Full stop. The deputy sheriff of this court shall take custody of the contemner at the earliest in order to implement the above direction. Full stop. Next para. Necessary subsistence allowance shall be paid by the petitioner upon making an inquiry as to the quantum of the same from the office of the deputy sheriff within 48 hours. The parties shall act on the order dictated in open court for the purpose of compliance. Puts up next para. We make it abundantly clear that it will be open to the petitioner to separately seek implementation of the order under contempt by way of appropriate mode, comma, be it attachment, comma, separate imprisonment or otherwise as permissible in law for the for implementation of such order. Full stop. Next para. Nothing in the present direction shall come in the way of such separate application being made. Full stop. If such an application is made, comma, a copy thereof shall be served on the learned advocate for the contemner uh, in advance. Yes. Deputy Sheriff ke khobor din onake kache থেকে। Next. Please ask him to remain in court, in the courtroom. Yes.
কেন আমরা কমপ্লাই করিনি?
You're lucky that you have a lenient second judge. That's why you're getting 1 week. Yes. Hey. কেউ অ্যাপেল করছেন নট টু করুন অ্যাপেল ইয়েস you are for the other side
I'm for the alleged contempt.
you decide your period
Milord, I am the wife, Milord. This was Milord.
Doesn't make a difference.
Milord, Milord, this is Milord. করেছে তো
করেছে তোমাদের দুদিন last week he has not visited, but due to
last
operation last Sunday.
Last
Not-
Sunday it was not Milord. The child was not well.
What was the
Milord, every week, every Sunday, Milord, the father will meet the child. The child, Milord, and the mother will take the child to the father in a park.
so that has been compared with last Sunday
No,
Last Sunday not completed.
except last Sunday, other were complied with. Milord, the child was ill. Milord, I have the Milord medical certificates.
so put that by UFN affidavit give an advance copy to him
And my learned friend also, Milord, doesn't dispute that.
so should you drop the rule then
My lord.
should you drop the rule discharge the rule
No, my lord, I am not saying, but my lord, she was
Correct.
not visited the last week, my lord, due to his illness, my lord, he has informed me. But my lord,
So where is the contempt then where is the contempt then contempt is a deliberate violation the child was ill and he could not be taken what is the difficulty
so let it
we are discharging the rule if it's flouted in future actually
No,
flouted in
only-
future you can come up
only one prayer, my lord. My lord, visiting my lord, the no problem, but my lord, only I pray for my lord, in the during puja.
See, we cannot modify our parent order in contempt jurisdiction. For that, you have to file an application before the appropriate regular bench. The court is apprised that the minor child could not be taken in compliance of the order dated June 18, 2025 to meet the father on certain occasions at the designated venue due to the illness of the child. Next para, learned counsel for the alleged contemner submits that he is equipped with the relevant medical papers to substantiate such contention. Next para, however, learned counsel for the petitioner, on instruction, does not dispute such submission. Hence, we do not find any deliberate attempt on the part of the alleged contemner to flout the order of visitation passed by this court. The illness of the child on certain occasions, definitely furnishes sufficient ground for the alleged contemner stroke mother not to take the child for such visitation. Next para. Accordingly, no useful purpose would be subserved in keeping the rule alive. Hence, CRC 6 of 2026 is discharged with the above observations. The connected contempt application bearing CPA such and such is deemed to stand disposed of accordingly. Next para. Since learned counsel for the petitioner submits that the petitioner seeks further visitation during the upcoming puja vacation, liberty is granted to the petitioner to file an appropriate application in connection with the appeal before the regular bench for such relief, with an advance copy of such application, if filed, to the learned advocate for the respondent. Thank you.
Personal appearance is this one.
Personal appearance, needless to say, further personal appearance of the alleged contemner is dismissed.
Oh, my lord, this is my application. Lord, initially, my lord was pleased to passed an order of alimony to the tune of 30,000.
Please take, yes.
Initially, my lord was kind enough to please to pass an order of alimony to the tune of 30,000. Thereafter, my lord, some amount was paid. Thereafter, they didn't pay. I took out an application for contempt, my lord. Thereafter, my lord, they file an application for modification. Although it's just like a review, my lord. They have stated in that my
A
lord.
dispose of application. That was in a dispose of application. They have filed that modification.
Yes, my lord.
The application had been disposed.
Yes, my lord. And in that modification application, my lord, there was a directions for filing affidavits, my lord. That has been exchanged. Thereafter, my lord, they filed one supplementary affidavit last occasion. My lord was kind enough to
No, that
direct us.
modification and the contempt both are pending now.
Yes, basically that has to be taken up.
You have a resolution for an unfortunate reason.
Yes,
so
yes,
you
yes.
should not take up the matter today. What are you trying to file?
That affidavit, may I file that
Affidavit of?
Affidavit rejoinder, my lord. My lord, last occasion directed to file a rejoinder.
No, they have filed their opposition. This is a rejoinder to what?
Supplementary affidavit. Last occasion they have filed a supplementary affidavit.
Have filed that. You have taken that supplementary on record.
Yes, yes.
Yes, file a rejoinder.
We are filing the rejoinder, but they didn't file any reply today. But there was a direction for reply also to the rejoinder.
The rejoinder filed by the petitioner today be kept on record. Full stop. By the appellant, you are the wife. The appellant.
Yes.
In the main appeal. By the appellant wife today be kept on record. Full stop. The time for filing reply thereto is extended for a week from date. Full stop. Let the matter stand adjourned for the day in view of the non-appearance of the respondent.
Yes.
Yes.
Well, there is a very resolution for a very unfortunate cause. Well, I appear for the contempt, and I think
That is more unfortunate for you.
No, I think if my lords do not mind to spare us, since appearing for the contempt, that is why only to show regards.
There was no direction for personal appearance.
No, but still is a contempt, and is a modification as well a contempt.
Very well. The other side is also not there.
Yes, yes.
We are not recording any order, just
Yes,
making
yes,
note.
absolutely.
Fair enough. Yes.
My lords would be taking up this bench, my
We
lord.
don't know. That is a question we even can't
We'll
answer.
decide later.
We'll decide later, and
I only
there will be a prior publication in the list so that all of you come to know.
Item number 6.
6 and 7, my lord.
Other side is not there. This for the first time appearing?
No, my lord. I have served as per my lord's
Then
direction.
wait for at least today we can't take up because of today. We are just making not today.
Item number 8.
This matter, Lordship, I'm appearing for the petitioner.
Appearing for the first time?
No, this matter has already been fixed today in Supreme Court of India. And
In any event, we are not taking up because the other side is not there.
No, Lordship. So, Lordship, can I give the order of the court of today was a matter fixed?
Is there any order, interim order passed by?
I'm awaiting for the order from Supreme Court.
We're not recording anything. If you get that order, place it on the next
All
order.
right, Lordship.
If you don't get it, then suppress it.
Now, I just was supposed to give the last order, but fixed today and the cause list of that. Lordship. That's all right, Lordship. I'm grateful for it.
But I am appearing for the petitioner. This is an application for contempt. Evidence of service.
This is appearing for the first time, Mr. Bella?
No. Your lordship's direction was there to serve. We have served, my lord.
Yes.
Let me file the affidavit of service.
File.
কোথায় affidavit of service টা কোথায়?
That is also not there. Then your appearance cannot be recorded, Mr. Bella. If the affidavit of service is not there, your appearance cannot.
Possibility.
That is the sine qua non for appearance recording.
We have served, my lord. The order was there.
Identify করে
Affidavit of service has already been filed.
উনি আছেন জানি একটু আইডেন্টিফাই করতে
Oh, my lord, somebody appears on behalf of the contemner. Your lordship asked me again to serve again. We have also served upon. Initially, it was directed to be sub by
come
post.
prepared with those affidavits of service on the next day.
Affidavit of service to the original application that has already been filed. That is on
Let them
record.
come.
The last
They are not
occasion,
there.
my lord, they appeared, and
again ask for copy, again we have some copy of the contempt.
Take up when there is no resolution of the bar. Yes. Next.
Item number 11.
Noted. Same. Both sides are appearing. So serve a copy of your appearance before the bar. No, if both sides are not there, we are not taking. If there is extreme urgency, you cannot wait for a day, we will definitely take up. If both sides are present, we'll definitely. We are there to take up all matters. You can take up your matter also, but you will be embarrassed later on. You are appearing in 12. 12. Then come. Yes. 12 to 3.
Next one is sorry, my lord. I am on.
No deal.
I am appearing for the alleged contempt.
My lord, your lordship, this is my affidavit of service, my lord.
Just let us get the file first.
Your lordship will find from affidavit of service will when, oh sorry.
One second. দীপঙ্কর কি ওনাকে পৌঁছতে গেল জেলে নাকি? দীপঙ্কর কোথায় গেল? দাও তুমি ফাইলটা কোথায়? 12-13 এর পরেগুলো তো লাগবে, সেটা ডাকলে তখন আবার যাবে খুঁজতে।
ফাইলটা পাচ্ছি না।
12 নম্বর ফাইল পাওয়া যাচ্ছে না।
team actually.
12 নম্বরে ফাইল পাওয়া যাচ্ছে না কেন? পরেগুলো খুঁজে রাখতে বলুন। দীপঙ্কর পরেগুলো ইনশিওর করো। দীপঙ্কর কি ফাইল করছেন নিয়ে নাও। Yes, file your
lordship.
নিয়ে নিন ওটা।
10th July, my lord, your lordship directed me to sub copy of the contempt application. I have served, my lord. They have received this, my lord.
What is the nature of contempt, Ms. Maiti?
My lord, your lordship directed the
Records to be modified.
Palikhai at Egra to record the names of the.
Yes, what about it? You are for the BLR?
My lord, my lord.
What is your defense?
My lord, there is a long delay, my lord. I find, my lord, there is no justification, but may I humbly submit, my lord.
Why should
Now,
you
my lord,
give a rule of contempt then?
My lord, they are, my lord, they have started and taken action for compliance of your lordship's order. Kindly.
Every time they have to file a contempt application.
My lord, that is
You
certainly
dispose
not,
of the
my lord.
contempt by directing you to put in cost from your
That
pocket.
is 1 year back. That is your
My lord, tender
August
apology for that.
2025. my lord.
Apology won't do. Why apology? Why should
now
the
that
litigant come to
20
court every time?
After receipt of the application for
But I
contempt, they have started the proceeding, my lord, and notice has been served upon
Maiti, don't add to the effect.
my lord.
Don't add to the effect. It is unnecessarily amplifying the effect. You are trying to give an effect and you are amplifying that beyond proportion. If there is no explanation, what some explanation, no explanation is there.
But there is a.
You're saying
there
so
is some
boldly before a court of
explanation,
law.
I must very fair before your
We can
lordship.
kill
my lord.
people with
My lord,
behind our smiles. You remember that?
My lord, my lord.
Not
my lord.
literally, but
My lord,
figuratively,
the
yes.
transfer is, my lord, your lordship's reaction to, was to, my lord, correct the record of right in favor of the.
Why didn't you
transfer
do it?
my
That is
My
the
lord, that
purpose
is-
of a contempt.
my lord,
That
now they have already taken.
One
my lord,
second, sir. One
two
second. When
hearings.
was the order passed? 18th August 2025.
My lord, 1 year back, my lord.
So you'll have an anniversary next Tuesday. Why didn't you comply with it for 1 year?
My lord, now, my lord, they have already, my lord, started.
Why did they do it till now? That is my question to you.
My lord, my lord, they have instructed. I have, my lord, the instructions that SIR, those things
What
are happening,
SIR?
my lord, but those are not.
Forget SIR.
justified,
SIR is
my
a.
lord. That is why, my lord, the officers.
Now,
were
the next
released.
you will
Those
say
are my
COVID. Next you will say COVID pandemic.
instruction, but my so far as my understanding goes, my lord, there is no valid justification, my lord. I tender apology, my lord. I must be
Will
very
you do
fair
it?
before your
Within a
lordship,
week
my
you
lord.
do it.
My lord, they are, my lord, the difficulties now, what difficulty they are facing, my lord, they are asking for the, my lord, the successions and the death certificates and those things, my lord. And my lord, the petitioner, my lord,
Let us see the direction.
heirs of the petitioners, so
Let us
as
see
the
what
transfer
direction
is,
we had passed.
as
Let us
the
see.
as the transfer is, my lord, are
We
now
set aside
deceased,
the judgment and we
not their
directed.
legal
We
heirs.
directed BLLR to immediately modify to
My lord.
correct the records of rights by reflecting the name of the
Correct, my lord.
transferees.
Within 3 weeks.
And or heirs in the
Heirs,
event of
my lord.
demise.
Yes.
So original transferees have died.
Yes, my lord. Yes.
So what do you want now?
My lord, the
What
details of
paper?
the heirs, my lord. Hearing was conducted, my lord. Hearings were
Hearing has been
conducted. Yes,
conducted.
my lord. Yes, my lord. After filing of everything, my lord, they have initiated after filing of this contempt application. That is the most unfortunate thing, my lord. I'm tendering apology for that.
So when is the next date of hearing?
Hearing complete. I have to take instruction.
Completely. See, no further hearing on merits. No further hearing on merits. We directly
only
to
for
modify
only
because the
only
previous
to
round of
collect the
litigation,
details of the, my lord.
previous round of litigation is over.
Yes, my lord.
Now
Only
you have to modify only
my lord,
reflecting
only
the
to
names
collect
of
the details of the, my lord, the legal heirs of the
Exactly,
transfers.
the
My lord.
details.
My lord, they are not providing. They are not happy.
Everything on record. What my Lordship is
Indicate
submitting
which
without
page?
any instruction.
Indicate which page.
Your Lordship,
They are not appearing in the hearing also, my lord.
so that the
Why are
12.
you not appearing in the hearing is my thing.
My lord.
Why are you not appearing in the hearing? They are saying.
No, I appeared there. Who told you? Who told you? My client instructed me to appear and he appeared. Tell he has
We appear and
bring the air certificate, legal heirs. But all of them are on record.
no, record or not, you give copies to them. What is the
But
difficulty?
this
It's
is
for
those
you
are the
only.
petitioners of the heirs of the this is the this
You
is
furnish your certificates or whatever document is there to show
that
that
is
you are
the
the heir.
12th of August. I am day before yesterday. I am told
What?
to produce the legal heir certificate.
You have produced.
No, that I did not bring it with me, my lord. They have asked me verbally.
Within a week, give them a hearing.
My lord.
Within a week.
My lord. My lord.
We'll fix a date right now.
My lord.
When will it be convenient to your client? Ask him in this coming week.
Act of content already, my lord.
Lord, I'm leaving it up to your lordship,
Committed
my lord.
already.
Any day, my lord, your
We are
lordship.
fixing it on 18th of August, Tuesday. Give a time, 12 noon.
Any time, my lord. I'm leaving it up to your lordship.
They shouldn't be returned by saying that it is your lunch time.
No, Lord, that is
12 noon, 18th, we are fixing date and time in the office of the alleged contemner. You furnish whatever documents you have to, and within a further week, you will correct the records of rights.
My lord, my lord.
Learned counsel appearing for the alleged contemner is personally present in court today, as well as
No, my lord, he is not the alleged contemner, my lord. He's the
very
officer of the, my lord.
learned counsel for the alleged contemner submits on instruction that the order of this court could not be complied with due to reasons beyond the control of the alleged contemner. However, learned counsel submits that the alleged contemner has already initiated the process of hearing to satisfy himself about the particulars of the heirs and legal representatives of the transferees in terms of the order of this court dated August 18, 2025. Next para. In order to avoid unnecessary delay, we direct the petitioners to furnish all documents relating to their heirship of the original transferees on August 18, 2026 at 12 noon at the office of the alleged contemner, which is deemed as the next date of hearing. Full stop. Upon furnishing such documents, comma, the alleged contemner shall comply with the direction of this court by reflecting the names of such heirs and modifying stroke correcting the records of rights accordingly within a further fortnight thereafter. Full stop. Next para. The matter be listed on the next date when this bench reassembles for passing further orders.
Grateful to your lordship.
It is made clear that no further notice of hearing shall be required. আরেকটা লাইন দিয়ে দিও এফিডেভিট সাইজ ফাইল টু বি কেপ্ট
Grateful to your lordship.
Item number 13, sir.
In connection with CPN 335 of 2026, I was appointed as an advocate commissioner on the previous occasion and
advocate on record for both the parties.
Both the parties. Now, I am filing advocate commissioner's report before your lordships. A terrible condition.
You are not Mr. Subhashish Majumdar?
I am Subhashish Majumdar.
You are appearing for the petitioners.
I am appearing for the petition.
What are you submitting here? Who appointed you as advocate commissioner?
In connection with the previous occasion, advocate commissioner, both the parties. Both the parties will.
There were two eviction suits, my lord, both filed by us. Now, my lord, one, my lord, we have taken possession since my lord has already rejected the stay application. This is the other appeal from the other degree. Now, my lord, they have filed the.
What was the other degree? Another
eviction. Both are eviction.
Another property.
No, same property.
Different parts.
Just a second. Lord, one is a suit, my lord, under section on the grounds of section 6 of the West Bengal premises.
The other portion is trespass.
Exactly. Other portion is trespass. Now, my lord, one, your lordship.
Section 6 has been decreed. You have obtained possession.
We have. The section 6 is pending. My lord, the appeal is pending. The other
trespass part has you have taken possession.
Possession through my lord, police help and the bailiff.
All right. Then.
Now, my lord, my learned friend had filed this contempt, my lord, on the ground that there is an order of stay, and my lord, on the garb of taking possession, the bailiff has, my lord, also my lord taken
the section 6 part.
This part 9A. Now, my lord, on the last occasion, my lord wanted to appoint an independent, my lord, advocate, special officer who will escort the petitioner, my lord, to the suit property.
His client.
Yes. Now, my lord, my learned friend, my lord, said that would be.
Wait. We'll open everything.
Now, my lord, since my learned friend said that it would not be possible for her client, my lord, to bear, my lord, the expenses, my lord appointed the advocate on records of both the sides, my lord, on an appointed date and time to who will visit the police, who will visit, my lord, the.
So both of you went there.
Went there, they came in terms of your lordship's officer, police officers also came. Since my lord, they say, my lord, they will be, my lord.
Possession was given.
No, they went away. They did not take possession. As of today, my lord, I am not sure, my lord, whom my learned friend is appearing because the applicant, my lord, I am told, my lord, he has committed suicide.
Yes.
There are two applicants.
Two applicants. Petitioner number 1, but plaintiff number 1 committed suicide, taking poison.
And petitioner number.
Horrible episode. What had happened? I have to say, your lordship, before your lordship, that taking 9 order, the landowners possess the 9A apartment. And
this is a joint report by both the commissioners.
Now, this is my.
There was no such direction.
How can there be separate reports? You did not directly report. We appointed special officer only to give possession.
Open at page number 50, your lordship. It made clear that in pursuance of the stay order passed by this court, the possession of the petitioner in respect of the subject shall not be disturbed in the meantime. Shall not be disturbed. But It was.
Have you got a copy of our previous order dated 10th July? Please open the 10th July order.
10th July. Page number?
10th July order. High Court আগের দিনে judge.
Come to para 5 of that.
Para 5, huh?
No, sir.
In order to
এই এটা
ascertain
ফেরত
the
দিন তো,
correct
আগে
picture
ফেরত
of the
ধরান।
matter, we direct the learned advocate
You
from
take
the
this back. Take this back. Read para 5. Read para 5.
advocates on record for both the parties to accompany the petitioners to the suit premises 11th July 2026 at 12 noon in order to visually inspect as to whether the said room in question, room number 9, is lying vacant. This is, I have to say.
Read on. Read on.
The petitioner in the contempt application shall enter the room if so.
We did not call for any special officer report or anything like. We asked you, both of you, to accompany the petitioner and so that she can enter the room if it is vacant. What did you find there?
But
we didn't direct any report. Keep the report with you. What did you find there?
I have to say that taking nine apartment, taking the order of 9 apartment.
9 apartment?
At the threshold of the first floor, 9, room number 9 is situated. But taking the 9 apartment.
Is the room now vacant?
They conceal, seal, pasting, plywood, and main door was demolished.
So you cannot enter now. What can be done?
This is the misdeed done by the landowner in connivance with police, and they did not pay heed with regard to your lordship's order. I perceive this matter.
Did you? The room is no longer vacant. We asked you to see whether the room is vacant. If so, you will enter. See, there is no vacant room. That room is not vacant.
No vacant room.
And what about you?
It was occupied and sealed by plywood and all the material.
What was sealed? The door was sealed by plywood.
It was sealed by plywood using nails.
Did not show that. It's very ominous.
And the main building, behind them.
After 3 p.m. that those nails are required for our heads.
No,
nothing enters our heads after 3 p.m.
That all the gates were.
We are sitting only up to 3 today. This bench. Please come back whenever we sit next. Just keep a watch on the list. We'll publish in advance when we are sitting.
They tell lies because they can pretend that they know.
That Mr. Bhattacharya is habituated. Yes.
But I have to say that they tell lies. They occupied this 9 order, taking 9.
Mr. Chatterjee, you have to deal with this.
9 apartment. This is the effect misdeed done by the landowners in connivance with the police. What can I do?
No, you remain till this matter.
Seeing the horrible.
Yes, we have to rise quickly, Mr. Bhattacharya.
Plaintiff number 1 comment.
Say what you have to say. We'll rise now.
Correction, because payment is being held. I will be this next day, when your lordship says.
Not like this. On the next day when you sit, just mention it when you sit. We'll try to take it.
Lord, may I be permitted to, my lord, may I be permitted to mention item number 16? This has been wrongly listed before this bench because the contempt arises out of a different bench's order comprising of your lordship and Honorable Justice Supratim Bhattacharya.
16 একটা দেখে নেবেন 16 একটা
date has been fixed on.
We don't know when we will be able to sit next because we are sitting separately. We will publish in the list previously so that you get advance.
Great injustice had been done.
No, that we.
This is the effect misdeed done by
Act order since this. Since the
that is why
the contempt application arises out of an order passed by a different bench, comma, let the matter be listed before the said bench. Different bench আমাদের সুপ্রতিমের সঙ্গে বেঞ্চ যেদিন থাকবে মিলটা দেখে নিন সিলটা আছে ভুলে গেছেন এসব হয়ে গেছে কলটা করা বাকি আছে বলুন আগে ফাইলটাও নেওয়া বাকি আছে You are not appearing in this meeting. Not look.